Good morning, everybody. Happy Thursday. Welcome to TCF Live. My name is Dan Soul. I will guide you through the next 4 hours of hot action from Courtlandia. Let's start. Judge Middleton.
Charge. My name is Judge Middleton. I get to keep my sign there, at least for the rest of the day. And we're going to talk about your case. This distinguished gentleman on his phone over here is Mr. Keith Stickley. He is the Chief Public Defender for St. Joseph County. Good morning, ma'am. Why don't you just come in and have a seat? Right over there on that side. All right. We've also got Deputy Paul here to help us. He's the first person I see every day. When I call your name, I want you to come right up to the podium and we will talk about your case. Let me get into the system here. We don't have paper files like we did in the old days. Everything is electronic. So it takes me sometimes a bit to click into it. The first person to check in was Jared Tuttle. Would you come up to the podium, please?
Is that right?
Yeah. Okay. Good morning, sir. Are you Jared Allen Tuttle?
Yes, I am.
You're from Angola?
Yep.
You drive up from Angola this morning?
That's where I live. Yeah, I stayed with my mom last night in Wolverville. She drove me up here.
Well, let's talk about the charge. The allegation is that on January 9th, you assaulted Brandy Gillespie here in St. Joe County, someone you had a dating relationship with. We get literally dozens or hundreds of these in the course of a year. It's called domestic violence or domestic assault. It's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Anyway, this was an incident that happened at Laura Drive, apartment B in January with getting kids up for school and angry temperatures and tempers. Mr. Stickley, have you had a chance to discuss this with the defendant?
I have, Your Honor. At this time, he's going to ask the court to enter a plea of not guilty. It's not a matter of free trial. It would be appropriate to appoint an attorney for him as well.
All right. Who lived at the Laura Drive address?
Me and Randy both did.
Were you on the lease?
Yes.
All right. So you're out of there as a no contact provision?
Yep. But she filed I have a court date here May 6th, but she wanted to vacate the no contact order.
All right.
And I guess she has talked to the prosecutors. She didn't want charges pressed, but they took it up anyways.
Well, it's the people of the state of Michigan versus you, and so the prosecutor
Has to.
asked, and so we'll see. Anyway, I'll show you plead not guilty. Do out of apartment. Going to appoint an attorney. Set an attorney pretrial for May 1. We are going to be very busy on May 1. All right, I'm going to send you out with the court officer. Did he get printed? And they're going to give you some paperwork with your lawyer's name and number on it. This is important. I want you to call the lawyer and discuss this with them.
Okay.
Prior to May 1st, and then you'll be here in the other building. By May 1st, we'll be on the other side in the big old historic courtroom. This charge has got different ways it could go. It could be a dismissal, could be a reduced charge, it could be a plea with a probation deferral, it could be a trial. But they'll get the police report, get victim input, be in a position to make some decisions about how to proceed on May 1st. So you make sure you contact your lawyer. I'll see you on the other side on
Thank
May
you, sir.
1st.
By the way, I watch you every day.
All right. Well, thank you. I'd say it helps people sleep at night because it's so boring. Audrey Clark. Good morning. I have some other visitors here today. Kelly was just here. I didn't know if you guys got arrested or something and needed to get arraigned. Some other friends are here to visit on our last day here. Good morning. You're Audrey Sue Clark?
Aubrey.
Aubrey. Yes, Aubrey. No, but they didn't write it wrong. I just read it wrong. You're charged with the infamous offense of no insurance. We get hundreds of these. It's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $500. Carries no fine of not less than $200. So the minimum fine for this is $325. Rarely does anybody go to jail for this. There is we've got a couple of these today. There is a lesser offense known as no proof of insurance. And that's a civil infraction. It's not even a crime. Mr. Stickley says you have insurance now on the vehicle.
Yes.
Who's your insurance carrier?
Progressive.
You got a lot of Progressive. That's our goal, is to help people get insured. So what I'm going to ask you to do is have a seat for a minute. We're going to get a couple of these and we will enlist the help of the prosecutor. The prosecutor has the authority to reduce the charge. The judge doesn't. But almost always when the people come in and prove that they have insurance, the prosecutor is willing to reduce it, which will save you a whole bunch of money, and it won't be a misdemeanor, and it will be just a civil infraction. So you have a seat and we'll come back to you in a bit. Is Ashley Armour here? Surprised she's not. I took every paper clip out of here. This thing is stripped down. I didn't even have any judgment forms here. Well, let's talk to somebody that is here. Stephanie Smith. Well, Miss Smith, I've misplaced your file. I don't know if I've misplaced it or just don't have it.
No, it was amended. I don't know if that matters.
Well, you're on the docket. I don't have the sheet. But very often when something's missing, it's right in front of my face. This happened the other day. I was looking for a file and I just didn't have it.
Well, that matters. I do believe it's a felony file, Your Honor.
It is. Well, we'll make it work. I don't have the ROA face sheet on Stephanie Smith, but we're going to do it from here. She's here. File number is 26603FY. Ms. Smith, you're charged with possession of methamphetamine as a second or subsequent offense. That's a felony. It's punishable by up to 15 years in prison and a fine of $25,000. I don't know if anybody's ever done that, but that is the maximum fine. It's alleged that you have some sort of odd felony in Indiana. Because this is a felony, I don't have jurisdiction to take your plea. Don't take all that. I moved them so they'd be out of the camera. Anyway, Ms. Smith, I'm going to show that you're pleading not guilty. Do you still live on 2nd Street in Constantine?
Yes.
Good morning. We could have done this the other day. I was teasing you about whether you were supposed to be here. If I'd known that, we could have.
I'm really not supposed to be here.
Well, all right, you were here to support him. Now he's here to support you. That's
That's
how.
what family do.
That's how that works. All right, we'll get to that in a minute. All right, Ms. Smith, I will show that you're pleading not guilty. Thanks. Set a pre-exam conference. That will be on April 21st. And if we need a preliminary examination, it will be April 28th at 1 o'clock. Your next court date is Tuesday, April 21st at 8:30. It will be over there in the other building. But by the time you get here, the bailiffs will send you where to go. It's on the 3rd floor of the older building. Anyway, also I'm going to appoint an attorney. What's your occupation? What do you do?
I'm a stay-at-home mom.
Okay. Well, stay at home. Don't get in any more trouble until we address this. So I'm going to have the court officer take you out. We'll appoint an attorney for you. You'll meet with the attorney, discuss this. I don't know anything about it. There is an affidavit, but I haven't looked at it yet. So I will see you April 21st. That'll be my first day in that courtroom.
Okay.
So we may have some stumbles, but I'll be there. I want you to be there. So you call your lawyer and I'll see you on Tuesday, April 21st at 8:30.
Thank you.
Morning once again, everybody. TCF Live. It's a Thursday. Good to have you all here, or Friday Eve as I prefer to call it. A little bit of a slow start this morning in Courtlandia, but there are some courts that have turned on their cameras. They just haven't started proceedings yet, but we'll continue to ride with Judge Middleton for a while.
Don't look so scared. Nothing terrible is really going to happen here.
It's my first time, but I'm not.
Well, you had your first time on our last day.
So I put it in a plastic bag.
File number is 26397SM. Ms. Hainer, you got charged with the same offense as Ms. Clark, no insurance. And it appears that you're showing that you now have insurance.
Currently not, but I got a job close by so I can walk to. It's kind of just gonna be parked, if anything, getting rid of it soon.
All right, well,
Then I would suggest that we still
have a
still
pretrial.
talk- Yeah, I think a pretrial with the prosecutor.
What do you do, Ms. Hainer?
I just recently got a new job at a small gas station nearby where I stay.
In Vicksburg?
No, I stay with my friends in Decatur. Yeah, it was just a rough patch, but
Well, this is not exactly the crime of the century. It's a strange offense. It is it's not in the motor vehicle code, it's in the insurance code. All the motor vehicle stuff starts with 257. Drunk driving is 257,625. The insurance code all starts with 500, and there's a lot less things in it. But you're charged with operating without insurance. It looks like they gave you a warning for no plate and defective equipment, one headlight.
Yeah.
And I say this a lot, one headlight will get you pulled over every time because they'll say, hey, your headlight is out. And hey, do you like the wallflowers? But we'll have you meet with the prosecutor. They're gonna meet with another person. What did she show to you?
I was looking at, I didn't have her contact info. I thought it was different in the.
Just
Oh,
the ticket.
oh,
just the
Yeah.
actual ticket.
It was a 2021 Toyota. Looks like a nice car.
Yeah, I wanted to beat her, but you know, dealerships.
Well, I've had my
Pickle.
share of beaters, but my car now is okay. You have a seat, Miss Hainer. We'll have the assistant prosecutor come meet with you here in a minute. William Lowry. Good morning, sir.
Morning.
Didn't we just do this a while ago?
Yeah,
Let's talk about your stuff. This is William and Eugene Lauer here in Centerville. He is charged with driving suspended on February 26th of 2026. He liked that so much, he did it again on March 6th, 2026. And charged with driving suspended second offense. Driving suspended second offense is punishable by up to a year in jail and a fine of up to $1,000. Carries 2 points on your driver's license and requires your license be suspended. You have several cases set for jury trial in May. You have an unpaid driving suspended ticket from 2024. You have an assault and battery, trespass, and stalking, all set for jury trial for April 27th. That must be in front of Judge Pattison. And you got 2 driving suspendeds in a month. So let's get you a lawyer. Who is the attorney on your?
Tim George.
All right, I'm going to appoint Mr. George. May resolve all this. Now, a couple things. You live right here in town, so
Yeah,
you
yeah.
walked over here.
Right.
Stop driving.
They took my car. I can't drive anymore, so.
Well, eventually they will do that.
Mm.
This is 436 ST and 439. Maybe we can resolve everything all at once without the need to bring in 30 jurors to resolve these other cases, but both cases. Appoint an attorney. Tim George. Set attorney pretrial. I don't know how we're gonna do May 1st. We may end up going into the afternoon.
It's a big courtroom up there. All right.
But I can only, I did 26 or something, but even at 10 minutes of plea, there's only, and some take longer and it's a very trying morning, but we end up going into the lunch hour, but we have the cases and we have to address them. All right, also has Mr. Lauer, are you working somewhere?
I'm trying to find it, with my felonies, it's really hard to get a job, to be honest, especially with no car in this town, so
Yeah, there's not a lot of
I mean,
employment
I'm
opportunities
doing what I
here.
can, so I'm paying on my fines, but
I see that.
it's mowing lawn and doing whatever I can here and there, to be honest.
All right, well, we're gonna get the same lawyer. We're gonna set this for May 1st at 8:30. And Mr. George can look at this and your other cases. I want you to continue to pay on your payment plan. Don't drive. Stay away from the person that you're accused of stalking. And we'll see, maybe we can come to some all-encompassing resolution on May 1st.
All right,
So good luck, sir.
thank you very much.
Is Jamie Schrock here? Good morning. Somehow you slipped. They didn't get your name down, but I saw that you were there.
You can take it off.
Too late now. Already called your name, and this is some not good stuff.
No.
This is file 26502FY. Mr. Schrock, you're charged with assaulting Amanda Binkley by strangulation, someone you had a dating relationship with. There's a specific kind of domestic violence that involves strangulation, choking. People often misspell it as chocking. You're also charged as having 2 previous domestic assault charges, so they charge you with a felony, 3rd offense domestic violence. You're also charged as a 3rd habitual offender, which would theoretically make the first charge punishable by up to 20 years in prison. So this is all serious as a heart attack. And so my recommendation at this point is you plead not guilty and I appoint an attorney to help you with this. Now, you were on Borgett Road. Are you out of the house or is she?
No, I'm back. She left and I come there and I finally, the St. Joe County cops wouldn't take her away. So I called state police and state officer Bauer made her leave.
What'd you do? Catch a red eye or something?
Yes.
Lie. That's a surprise.
Her whole scheme was, her and Deb Davis was, they plotted this thing to,
All right, well, don't say any more about it.
well, that's exactly what happened.
All right, well, I'm gonna get a lawyer to help you with this.
Thank you.
You're talking about Prosecutor Davis?
Yes, ma'am. Yes, sir.
All right, again, we'll get a lawyer and you can discuss this with them. I think Miss Binkley, she had some warrants of her own. I'm not sure where she is. Let's see who authorized this. Miss Davis. Anyway, these are very serious charges with the supplemental and the previous convictions, and so it is important that you have an attorney. Set a pre-exam. I'm busy on April 21st too. I'll come back with a bang from vacation. April 21, 2026 at 8:30 for a pre-exam. Preliminary examination, if needed, will be April 28th at 1 o'clock. Now, I don't think you owe me any other money. You're not on probation or parole anywhere. That's all over with.
I'm paid up.
All right, it doesn't show that you
I
only.
even got my license back, so I'm waiting. for
Well,
that.
I am glad about that. But I don't know what to make of this. So did he get printed?
Yes,
Didn't?
Not yet.
All right. Well,
when I got arrested, I did.
well, they got an F on here that said you need to get printed, so we'll see what the deal is. When you go with a court officer, we'll get a court-appointed attorney for you.
Thank you, Joe.
Okay. Anthony D. Grant. They didn't actually come here to support you. Well, maybe they did. I don't know. Oh, you did? Oh, I thought it came from me. I didn't think it came from you. It was just an accident. They were here on the last day. Anyway, this is some more serious business. This is Anthony Dwayne Grant Jr.
No. I'm Anthony Dwayne Grant, number 1.
Well, they got Junior on here, and we better straighten.
That's my
that.
son.
Well, this is some serious mistake. Let's see where that happened. That's a big deal. We had a guy the other day and I said, hey, you owe me a bunch of money. And he said, that's not me, it's my son. But this is, so they show you as Anthony Dwayne Grant.
There's 4 of us, Your Honor.
Yeah, but the complaint somewhere, somebody put Junior on here. I'm trying to figure out where that happened. The prosecutor did it when they charged it. We need to fix it. Anyway, the allegation is that you did threaten and discourage or attempt to discourage Jason Van Dyken. You knew it'd be a witness. It's charged as in impeding, interfering, or obstructing a witness. So those witness intimidation, that's a felony punishable by a 4-year imprisonment. You're also charged with resisting, obstructing a police officer, 2 counts on Deputy Van Dyken, and you're charged as being a 4th habitual offender. So this is serious stuff.
Your Honor, I don't have access to the, like that confidential ID form or whatever, but before we go through with the arraignment, does all the other things outside of his name actually match?
Well, let's see. Good. The booking information did. I don't have a criminal history in here. I don't know why I don't.
Maybe that personal protected information sheet. I don't think it's necessarily fair to arraign them if we can't positively identify.
Well, the complaint says Anthony Dwayne Grant, signed by Deborah Davis on March 21st. Then
There should be a personal identification sheet in there as well.
Then they
which is
filed-
DOB.
well, there should be, but there isn't. Can anybody help me here? There's no criminal history. There's a complaint, then somehow it got amended. The date of birth is no longer on the warrant, which is very. Oh, there it is. It's no longer in the system. Your DOB is 1963. Were you born in 1963? Before the Beatles.
Junior or senior?
It's senior, but the original complaint came in as Anthony Dwayne Grant. Somewhere it got changed by the prosecutor to Anthony Dwayne Grant Jr. The bond form is Anthony Dwayne Grant. He posted a bond of $6,000. There's no criminal history in here. This is senior. Anyway, Mr. Grant, the clear import here is we need to get an attorney to help you with this. This happens from time to time with a misidentification. And it can be important. For example, there's probably 8 or 10 guys in St. Joe County named Michael Klein. And some of them have the same middle name. And it has happened in the past where they arrested the wrong person. I can think of one notorious case where the state police arrested a school teacher from Sturgis, from Coldwater, and she wasn't the right person. She spent Thanksgiving weekend in jail. She was mortified. And I can think of another case where 2 guys worked in a RV factory, and one of them was selling drugs, and they both had the same name, and they arrested the wrong guy because they weren't careful about the identification. So we are very careful about identification. Anthony Grant number 1. We'll sort this out. In the meantime, I want to show you're pleading not guilty. I'll appoint an attorney unless you intend to retain one. Do you want me to appoint one for you?
Well, I'm gonna need something because I've lost jobs, $80,000 job, $14,000 job. They still won't return monies from me till I have an affidavit.
Who's
So-
they? The state police, the sheriff's department?
Yeah, you know, well,
All right, I'm gonna set a pre-exam conference for 4/21/26 at 8:30. Pre-exam, if needed, would be April 28th, 26 at 1 o'clock.
this, I just want to put it on record. This stop was a stop. It was unwarranted at all.
All right, well, we'll sort that out. That's one reason why you need an attorney. There isn't any information in here.
Sure there isn't.
Well, there's no affidavit because they made a warrantless
Sorry.
arrest. And the bond information sheet, Kyle Singler, we talked to him the other day. During the contact with Singler, his passenger, Anthony Grant, was yelling not to comply. Officer Flynn, he wouldn't get out of the car, wouldn't answer the door, open the door. I can't tell how this turned into what it did.
I said anything.
All right, well, don't say more about it. This is a case where an attorney
All right, sorry.
could really help you. There are
Yes, sir.
some
Yes, Your Honor.
defensible defenses here.
Yes, Your Honor.
All right, you posted your bond. You're not a flight risk. You've appeared for everything.
All the time.
I don't know, he's got a print order on here. One of my sore points is they arrest people at the jail and they don't fingerprint them. They don't even know who they are. They could be the Gilgo Beach killer and they'd let them out without knowing who they are. So we have our own live scan equipment and we fingerprint them here. So Mr. Grant, there's some issues here. They're gonna need to be cleared up. And we'll get a lawyer to help you with this. And I don't even need to tell you this, but what I want you to do is call your lawyer, make an appointment to discuss it with them prior to April 21st. And I will see you on that morning and we'll see where we're headed with this thing. So you go with the court officer, we'll get your prints and you'll get your court appointed attorney. You're good to go.
Thank you, Your Honor.
All right, thank you. Dress for the occasion, which
All right, friends, TCF Live. It's Thursday. Good morning once again. My name is Dan. I'll be with you for another 3.5 hours or so. Programming note, yesterday we were watching that preliminary exam in Judge Wiggins' court. They did continue with it in the afternoon. We will show you what they did in the afternoon during the 4th hour assuming something more important does not come up. Let's change it up. We have other places we can go now. Let's go over to Washtenaw and Judge Simpson. Say good morning to him.
This honorable court in the office of the public defender. While the people do not believe that any such conflict exists, we make this waiver in the avoidance of all doubt.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender. We do not believe that there is a conflict, but if there is a conflict, would waive the same.
Court for its part also does not believe there's a conflict either in Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court calls the case People of the State of Michigan versus Derek Jones.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Jones. Mr. Jones, would you please state your name for the record?
Derek Jones.
Good morning, Aubrey. People.
What are we doing?
Your Honor, we are asking for a preliminary examination. Mr. Jones wishes to appear by Zoom. So Mr. Cook said that he would be able to do a writ within 2 weeks as opposed to the normal time. And we are asking that
A preliminary examination by what kind of case is it? Because the court has to make a determination as to whether or not it would be appropriate for a Zoom.
Your Honor, may we approach briefly?
May. What? For James. Discovery is complete.
Yes, Your Honor.
People would have their witnesses available the 21st.
We'll do our best, Your Honor.
Preliminary examination. I will indicate that the defendant may appear via Zoom.
Thank you, Your Honor.
Preliminary examination will be set for April 21st, 2026, 9 a.m. before Judge Garwood. And will continue. Thank you. Court calls case People versus Evan Sherbert.
Your Honor, Raymond Cook. Good morning, Your Honor. Assistant Bud Defender Davi Leva on behalf of Mr. Sherbert.
Sherbert.
Evan Sherbert.
Okay, thank you.
And Your Honor, requesting adjournment so I can review an offer that I received.
Probable cause conference will be adjourned to April 23rd, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Court calls case People versus Cecilia Cotton.
Overwater Assistant Prosecuting Attorney for the People.
And Assistant Public Defender Nick Bukovich for Mr. Cotton.
Sir, state your name.
Cecilia Cotton.
Thank you.
At this time, Your Honor, we are requesting adjournment to further negotiations.
You want 2 or 3 weeks?
Whatever the court deems appropriate. My client is in custody till December.
Yeah, I see that. So, probable cause conference, April 30th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Larry Evans.
Overwater Assistant. People.
Morning, Your Honor. Edward Dukes on behalf of Larry Evans.
Your name, sir?
Larry Evans.
Thank you.
Your Honor, we're asking for an exam.
Sir?
We're asking for a preliminary exam.
Discovery is complete.
To our knowledge.
People have their witnesses available the 23rd. Preliminary examination in person, April 23rd, 2026. And bond or before Judge Washington. Bond continue.
Thank you, Your Honor.
Court calls case of the People versus Travis May.
Go by the prosecution.
Edward Lucas on behalf of Travis May.
May, can you unmute and state your name, please?
Yes, my name is Travis May.
All right,
Thank you, Your Honor. There is some negotiation that's underway. I'd be asking for an adjournment.
Probable cause conference will be adjourned April 30th, 2026, 9 a.m. Bond.
Thank you, Your Honor.
Thank you, Mr. May.
Thank you.
Court calls the cases of the People versus Corey Jones, 2 cases.
Edward Lucas on behalf of Corey Jones.
Your name? Corey Jones. Thank you.
At this time, I'd like to set both these matters for exam.
All discoveries complete.
To my knowledge.
Were other witnesses available the 23rd? Preliminary examination in person, April 23rd, 2026, 9 a.m. before Judge. Yeah. That'd be Garwood. It's Garwood. Bond continued.
Thank you, Your Honor.
Thank you.
Court calls case of the People versus Malik Asadi.
Overwater Assistant Prosecuting Attorney for the People.
Good morning, Your Honor. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Shanazi.
Pardon?
Shanazi, I'm sorry.
I can really, you don't even know who you, what?
I can't say her name.
What? Tanaza? I can really, right?
Yes, her.
Supervising you?
Yes, her. Mhm.
You're doing a very good job. Don't know her name. All right. I figure this is the last time I'll grant permission to you.
This is.
Well, it has been an absolute pleasure here.
Likewise. Likewise, thank you.
Starting now into practice, isn't it?
And we would like to adjourn in order to submit plea paperwork.
To plea paperwork? You just need. Where's your client? Asadi? On Zoom? Oh, not here.
Oh, sorry. Oh, thanks.
No, it's not your fault. I know whose fault it is, Miss Cannon. All right. You needed to get the paperwork in.
Yes.
Probable cause conference will do April 16th.
Or 6.
2026, 9 a.m. next week. Bond can.
Thank you, Your Honor.
Court does call the case of the People versus Keontae Jones.
Good morning, Your Honor. Edward Lucas on behalf of Keontae Jones.
Your name? Keontae Jones.
We'd like a preliminary examination, Your Honor.
Discovery is complete.
My knowledge.
People have their witnesses available the 23rd. Preliminary examination in person, April 23rd, 2026, 9 a.m. before Judge Washington. 21st, I'm sorry. Where were we? April 21st are all of these. April 21st, 2026, 9 a.m. before Judge Washington. We're gonna have to correct all of those other ones. Bond continued.
Thank you, Your Honor.
Court calls the case People versus Daryl Gardner.
Morning, Your Honor. Raymond Cook for the people.
Ready, Your Honor. Robert J. Kilwell, Judge. I'm on case 0212 FY.
All right, thank you.
Assistant Public Defender Dave Lee, also on behalf of Mr. Gardner.
Daryl, would you state your name for the record?
Daryl Gardner.
Thank you, sir.
Judge, on my matter, I'm set exam.
And Your Honor, on my matter, we are waiving. Mr. Gardner, may I sign the form that I reviewed with you yesterday on your behalf?
No, we wasn't able to sign it, but I'm ready to sign it.
May I sign it on your behalf, sir?
Oh, yes, sir. Yes, sir. Yes, sir. Absolutely.
All right, that's a case of malicious destruction of personal or police property.
It is, Your Honor.
All right. On that case, Mr. Gardner, you're waiving preliminary examination.
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you could.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution on that matter.
Yes, sir.
People also waive their right.
Yes, Your Honor, there was an offer made on that case. And I put that on the record.
Yes, go ahead.
The offer was to waive up to circuit court on people that agree not to add an individual.
That is correct, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single count.
Your Honor, we acknowledge receipt of the information. We waive formal reading and ask for a pretrial date, please.
Client standing mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
April 20th at 1:30 for judgment.
April 20th, 2026, 1:30 before Judge Hamoud.
Thank you, Your Honor.
Excuse me, what time will it be, sir? What time will the court be? April
For
20th?
for that case, it's going to be April 20th at 1:30.
At 1:30, all right. Thank you.
Before Judge Hamoud. All right, fine, we can continue on that case. And then on the other matter, discovery is complete.
Yes, Your Honor.
People have their witnesses available the 21st.
We'll do our best, Your Honor.
Preliminary examination in person, April 21st, 2026, 9 a.m. before Judge Garwood.
Thank you, Your Honor.
And we'll continue. Thank you.
They're all coming to see you in a couple days.
All right, Bob. Thank you.
Thank you, sir. Court calls the case, People versus Walter Peterson, 2 cases.
Raymond Cook for the people.
Good morning, Your Honor. Robert Ellman on behalf of Mr. Peterson on both matters. Mr. Peterson, can you please state your name for the record?
Walter Peterson.
Waiving on both of these.
That's correct, Your Honor. You should have 2 signed forms.
I do. Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged in each case was committed and that you committed it?
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes.
Will also waive the right?
Yes, Your Honor. Actually, this is an offer on the record as well.
May.
The offer was made to waive up to circuit court plead to the felonious assault charge in exchange for dismissal of the retail fraud, as well as there's an option being held open for the defendant to pay restitution on 2 other retail fraud matters in exchange for those cases not being.
Understood. Is that a correct statement, Mr. Elman?
Yes, Your Honor.
All right. Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Your Honor, we would stand mute and waive any formal reading.
And then having waived formal reading, standing mute to both counts cases. Court will enter a not guilty plea. Pretrial will be set in each matter.
April 21st at 1:30 with Judge Conklin.
April 21st, 2026, 1:30, Judge Conkey.
Thank you, Your Honor.
Thank you. Bond will continue.
Alrighty, friends, as bonds continue in Washtenaw County, let's go to Lake County, Ohio. Say good morning to Judge O'Donnell.
Thank you, Your Honor. We are here on the matter of the state of Ohio versus James Maxey, case number 25, CR 000-468. We are set today for a change of plea hearing. The defendant is present in open court with their attorney, Nicolette Tomazik. It's my understanding that the defendant will be pleading to count 1 and count 2 of the indictment. Count 1 being tampering with evidence of felony of the 3rd degree, count 2 being possession of cocaine. There's no agreement regarding sentencing. The state would request a pre-sentence report and drug and alcohol assessment prior to sentencing.
Ms. Tomazik?
Yes, thank you, Your Honor. That is my understanding of what's going to happen today. I did speak with Mr. Maxey, and that is how he would like to proceed today. Thank you.
Mr. Maxey, how old are you?
52, Your Honor.
How far did you go through school?
11th grade.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
PTSD, depression.
Are you being treated for either of those right now?
No, just through therapy.
What therapy do you have?
Signature Health.
Do either of those conditions affect your ability to understand what's going on here?
No.
Did you get a copy of this indictment?
Yes.
And you're pleading guilty to both charges, is that correct?
Correct.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question, then let me know. If you want to talk to Ms. Tomazik some more, let me know that, and I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have a constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No, Your Honor.
Do you still want to plead guilty to these charges?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes.
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
In count 1, tampering with evidence is a felony of the 3rd degree. It carries a 36-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes.
Count 2, possession of cocaine. It's a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
If you plead guilty to the forfeiture specification, you're voluntarily giving up those things listed. Do you understand that?
Yes.
I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term of 48 months and a maximum fine of $12,500. Do you understand that?
Yes.
Are you on post-release control to the parole authority?
No.
You understand your guilty plea may result in a driver's license suspension of between 6 months and 5 years?
Yes.
You understand your felony conviction will prevent you from owning or possessing a firearm?
Yes.
You understand that if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And if that were to occur, the maximum prison sentence for the violation would be the greater of 12 months with the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 48 months. Do you understand that?
Yes.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk with Ms. Tomaszek before pleading guilty today?
Yes.
Has she discussed everything about your case and answered all of your questions?
Yep.
Are you satisfied with the advice she has given you?
Yes, I am.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, I am.
Do you have any questions?
No, I don't.
All right, Mr. Knopf, if the case went to trial, what would the evidence show?
Your Honor, had the case proceeded, the trial, the state would have shown that on or about the 28th day of March 2025 in Lake County, Ohio, the defendant was walking down the street in Painesville when Painesville Police Department identified the defendant as someone having an active warrant through Menor. Painesville Police pulled up next to the defendant, turned on their overhead lights, and yelled, "James." The defendant stuck his hand in his pocket, went around a vehicle out of sight of Painesville Police, and dropped a dropped a crack rock on the ground, confirmed by the Lake County Crime Lab.
All right, Ms. Tomaszek, anything to add to those facts?
Nothing on the facts, Your Honor.
Mr. Maxey, did you hear what Mr. Knopf said, that the facts would show if the case went to trial?
Yes.
Are those facts true?
Yes.
What is your plea to count 1, tampering with evidence of felony 3?
Guilty.
What is your plea to count 2, possession of cocaine, a felony 5?
Guilty.
And what is your plea to the forfeiture specification on count 2?
Guilty.
Ms. Tomaszek?
Your Honor, I had an opportunity to review the written plea of guilty with Mr. Maxey before coming to court, and he's prepared to sign. Your Honor, for the record, Mr. Maxey and myself have signed the written plea of guilty.
And Your Honor, for the record, I have witnessed the defendant and defense counsel sign the written plea of guilty. I have now signed it myself, and with your permission, I'll return to the bench.
Okay. Mr. Maxey, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
I'll accept the written plea of guilty. Defendant was present. Ms. Tomaszek advised of all of his rights, being a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. I will accept his plea of guilty and find him guilty of count 1, tampering with evidence of felony 3, and count 2, possession of cocaine, a felony 5, and the forfeiture specification. I'll refer this for a pre-sentence report And a drug and alcohol evaluation. Sentencing will be May 13 at 11 a.m. Ms. Tomasic?
Yes, thank you, Your Honor. We did want to talk about Mr. Maxey's bond if the court would allow it. Mr. Maxey's bond was revoked last year around in June of 2025 for failing to appear for his pretrial. Your Honor, since then he has been in the Lake County Jail. He is currently serving a sentence through the Painesville Municipal Court. He is in jail treatment program right now. He is set to get released from that on April 14th. Your Honor, he's really enjoying jail treatment program. He said it's been extremely beneficial for him. He's been working with one of the counselors through JTP. His name is Dave, to get into signature health for outpatient. He also does have a great support system. His boss has been sober for over 40 years. Mr. Maxey's also willing to wear a GPS monitor if the court would allow his bond to get reinstated. Your Honor, Mr. Maxey would just like to try to continue on with this sobriety. As indicated, JTP has been very beneficial for him, and he would like to try to continue on, get his signature health, and get the process started of continuing on in his treatment. Thank you.
What's the sentence for that he's serving?
It's an M1, possession of, or, I gotta read it.
Okay. Your Honor, is a misdemeanor of the first degree drug paraphernalia. He had a needle on him. I believe with some drug paraphernalia in it.
All right, Mr. Knopf.
Yeah, the state would be opposed to reinstating bond. The defendant failed to appear at the last hearing. That's why the bond was revoked. But in addition to that, the defendant has multiple failure to appear on his record in multiple contempt of courts. And the whole reason why he was stopped in this case was because he had a warrant through menor muni.
This, you were arraigned on this case May 16th of last year. There was a pretrial scheduled May 22nd that you didn't, or I'm sorry, June 3rd. You didn't show up for it. Why didn't you show up for it?
My boss's truck had broke down. I did call and talk to the public defender's office and asked them multiple times what I could do. But to be honest, Your Honor, I was terrified. I've never had a felony before. I've never come to this court before. I didn't know what to do, and I had signed away my way right to a speedy trial, and I was terrified. I don't even have a better answer for you.
Well, Mr. Knopf indicates that you failed to appear several times before in other courts. Why is that?
The one that he was speaking about, the Menor one, it was all I had to pay a fine, and it was the first, or right after I was due to me to pay it.
Well, it seems like there's other, besides the Menor one, there's other failures to appear.
Yes, to be honest, I was a drug addict.
Okay, well, you are a drug addict. So,
correct.
So why would I let you out if you don't like to show up?
I'm changing everything in my life. This has been the first time in my life that I've addressed the trauma and everything that I've dealt with as a kid that I didn't know was underlying the issues. I have been involved with AA and that before, but the dual diagnosis part is huge for me. In the last 5 years, I've lost my whole family. I've lost my mom, my brother, my sister. For the first time, this is all hitting home to me. I haven't seen my kids in years. My daughter I have a grandson. Like, this is all changed to me. I don't know how else to explain it. I want to be a different man.
Well, then you should be. You should stop thinking about it and stop talking about it and start doing it. I'm going to change the drug and alcohol evaluation to a psychological evaluation. All right. How long is your sentence? I know you get out on the 14th, but how long was the sentence altogether?
It was 60 days.
Okay. What's the most time you ever spent in jail before at one time?
60 days.
This sentence?
Yes.
Or did you have another one like that?
Yes, I had another 60-day one.
Okay. When was that?
4 years ago.
Okay. When you failed to show at the pretrial in June, the offer was a plea to attempted tampering, a felony 4 and a felony 5, which Mr. Knopf was still willing to offer this morning, and I said, no, I won't accept that. You understand that?
Yes, I do.
Okay. Because you can't decide when you're going to show up and when you're not going to show up.
I understand that.
Okay, well, I hope you understand that, because I'm gonna reinstate your bond to what it was before. And I can guarantee you, right now, if you don't show up, or if you screw around out there, then you're gonna go to prison for 48 months. And prison for 48 months is a hell of a lot longer than Lake County Jail for 60 days. You understand that?
Yes, I do.
Anything else, Mr. Knopf?
No, Your Honor, thank you.
Ms. Tomazic?
No, Your Honor, thank you.
All right.
All right.
Alrighty, friends, let's go back up to Michigan. Say good morning to Judge Mom.
Your Honor, good morning. Richard T. Serrano, P33828, appearing on behalf of my client, appears to my right.
Good.
Thanks, so. But in the pre-trial, please state your name loudly for the record.
Heather King. All right, good morning. Well, we've been waiting a little bit for you, so I'm glad that you're here now. And counsel, as to the arraignment.
As to arraignment, Your Honor, this morning I've had an opportunity to interview my client and advise her of the nature of the charges against her. She understands all maximum penalties that are involved in this court or any administrative agency, and presently she's finding advice of rights as those. But we wait for reading today's stand mute.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment as to the pretrial counsel.
As to pretrial, Your Honor, my client's been taking progressive steps. This is a matter that she's going to enter a plea to the amended charge of no valid operator's license in her possession. I've explained what that entails to my client, both penalty wise. This court may or may not do. She understands the effect that it would have on her operator's license with the Secretary of State. And I'll address the issue of bond and what she has pending after the plea is accepted, Your Honor. With that, if the plea is accepted, the original charge would be dismissed on the prosecutor's motion.
All right. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. And ma'am, you heard the plea that was just placed on the record, correct?
Yes.
As to the amended charge of no operator's license on person, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights?
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights?
Yes.
No operators, like, you also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency?
Yes.
Knowing all of that, do you want to continue with your plea? Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? Any immigration issues?
Yeah.
Oh, sorry, no.
Okay, counsel, please order your client.
Is Ham on or about June 19th, 2021, were you in the city of Wyandotte?
Yes.
Were you operating a motor vehicle at that time?
Yes.
Did you have an encounter by the police?
Yeah.
All right, and that was for an expired plate, is that correct?
Yes.
Although you were not cited for that, did you subsequently get a new plate?
Yes.
And upon the officer asking for you to produce a valid Michigan operator's license, were you able to do that at that date and time?
No.
That's because it was not valid on that date, is that correct?
Yes.
I'm satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. And counsel, are you asking for immediate sentencing?
Yes, if the court would, Your Honor, just briefly allocate on her behalf. She is, as I said, taking proactive steps. He has other jurisdictions to address the same charge in Novi, in Armida, and in Dearborn. And she's contacted all of those courts. Is that correct, ma'am?
Yes.
Do you have any court dates set for any of them?
Yes.
Okay, that's good. And are you on probation or parole anywhere else?
No.
And do you have any other cases pending other than what I've mentioned?
No.
Okay, and my client is, right now she's babysitting to earn some money. She stays with her mother. Her mother is in the audience. She's the driver of my client. Raise your hand, ma'am. All right, it's even that marvelous Red Wing jacket there. So, and the,
She can bring them a few miracles.
I hope so.
Okay.
So any consideration the court could give to that, she's very sorry about her late appearance. That she's trying to take care of all matters. Right now, Your Honor, she's waiting to hear back from jobs applied to with the Detroit Public School Situation Board. Detroit Public Schools as a security guard. Is that correct, ma'am?
Yes.
And with that, within the court's discretion as the sentencing, Your Honor, she will need some time to pay.
Yes.
She'll be able to pay $50 today. Then
Okay.
payment program if the court pleases.
All right.
Throw away.
Yeah. Well,
Another spot.
oh, it's on. Oh, they're right here. Already grabbed them. Thank you. See, but it's easy to not find them because my desk is nice and clean. All right, so, ma'am, how many other matters do you have to clear up?
About 4 or 5.
Okay. Well, you have to start somewhere, so at least you're starting. The court's going to order a $200 fine, $200 cost, crime victim assessment fee of $75, justice system assessment fee of $50, because the court does not find that there's reasonable grounds to depart from MCL 769.5 and does not find probation would be appropriate. That's a total of $525. Is there a warrant fee and clearance fee?
There's a $50 warrant.
$50 warrant fee, $575 total. You're paying $50 today. Can you do $50 per month?
Yeah.
All right. All right. So let's do $50 per month beginning today.
Do you mind keeping in the middle of the month for your payment thing?
Yes, totally.
Let's keep it today. $50 per month, April 9th, which is today. Next one's May 9th.
Oh, okay. That is that.
Right.
Yes.
Okay. So please stop at the window. Somebody will be with you shortly and have a good day. No driving.
Thank you.
You're welcome. Okay.
Thank you, Your Honor.
You're welcome. Let's go off the record. Has Mr. Dox arrived yet? Mr. Dox?
Dox?
Yes, he was scheduled for 8:45. Okay.
Yeah. Ham, White, Gaines, Fisher.
Okay, and I see Ms. Kraus, although Mr. Cripps was supposed to be in person, so.
Ms. Cross is on the docket.
Oh, on your docket. Okay, great. Thank you.
What?
Yes, oh, I'm sorry. I thought we were off the record. Mr. Dox is not showing up for Mr. Rice.
He's on the Zoom right now.
Well, interesting because I told him he had to be in person. So,
It also has a matter at 10 a.m.
yes, he has a 28th district court at 8:30, a 27th at 8:45, and then a 10 a.m. Correct. Good morning, Mr. Dox. We're not doing this again. Mr. Dox, good morning. Are we muted? No. Mr. Dox,
The court took jurisdiction.
Good morning, Your Honor.
good morning. Please turn your camera on.
Good morning. I'm at the wrong, my camera is, I'm coming, I was just at your court, Your Honor. And I got confused. And I'm coming back, I'm coming to your court right now. I was just at the parking lot, came to Taylor because I'm coming to your court right now.
Wait. What is that, counsel?
I'm coming to your court in person.
Yes, because you were supposed to have been here for an 8:45 in person.
I
and
was
also-
there, Your Honor. I was there thinking that you were here in Taylor, and I came here to Taylor. I just spoke to the prosecutor. I was just in your parking lot, so I apologize. I'm just been a
Wait,
crazy
what?
day.
I'm still so confused, but you're interrupting me, so we'll see you in person in just a short bit.
Yes. All
Because
right,
you have
see,
people that were scheduled at 8:30 as well.
I was there. I'm sorry. I was there. All right.
I don't even know. I don't even have any words for that whole exchange. Why would somebody think that I'm in Taylor and not here?
Prosecutor is on something else and can't talk to him about the sales about 21 ago payments. So I'm going to check custodies if you're ready.
I'm looking at. Okay. I don't have any files.
Ready, Your Honor. Okay.
I don't have any files, yeah. Oh.
Good to see you today. I know. You have Carlton Gaines.
Yes. Let me go talk to him.
Is Mr. Gaines here?
Yep. Oh, yeah, he's here. I appreciate you calling me. So I gotta go to exam in Grand Rapids. I can't get a hold of that client, so I might drive all the way up there for,
Okay,
I'm predicting that that's what's going to happen today.
all right. So let's go on the record in the matter of the state of Michigan versus Carlton Gaines 26332.
Good morning, Your Honor, to you and your staff attorney Maxwell Doobie, P number 86012, on behalf of Mr. Gaines, who stands to my right. Please state your full name for the judge.
Carlton Gaines.
All right, thank you. And so today is the date scheduled for the probable cause conference.
That is correct.
Oh, hold on. There's another case for him as well.
It's a probation
File
file.
237. Do you have another file there, Dave? For Mr. Gaines?
Are they not, are they separate? Is that should
Hold on. There's only one that can be recorded at a time. 23703, probation violation.
No, I got one. For who?
Carlton Gaines. Yeah. All right. All right, so we have a probation violation hearing today as well as probable cause conference. So let's handle the probable cause conference first. And counsel, you want to set this for an exam?
Yes, Your Honor, I would have set for an exam. If possible, I was requesting the April 30th date. If
Oh, no, that's way too long.
too long.
Well, it's too far out for a number of reasons, but your client was arraigned March 16th, so that's way. And actually, we have a retrial that day, I think. Oh, that got switched. Oh, yeah, that got, I think that was resolved, but in any event, I'm not going out to April 30th, council, because that's too far on time standards. So can you do?
They're only Thursdays, Your Honor?
Yes,
Okay.
you can do them in the afternoon.
You can.
Yes,
Would you be able to do the 23rd in the afternoon? And the reason I'm asking for.
I'm pretty sure we can do the 23rd.
Yeah, I could do the 23rd, Your Honor, and this might get resolved. That's why we just a little more time. I have to do a little more work with Mr. Bresnahan on this one, and then possibly get him in sobriety court if that is part of the plea agreement. So that's why I didn't want to waste the court's time. If there is no offer, because as of now, there's no offer, I will hold the exam anyway. So I think that's perfect for everybody.
Okay. So I'll tell you the time here in just a moment.
I didn't realize you could do afternoon, so that's perfect. I appreciate that.
Oh, yeah.
Actually, you know-
Some days we do evenings.
So that's what I was gonna say. I know that's not ideal, so I appreciate you accommodating me.
Oh, I don't know if there's any ideal time around here anymore with our dockets.
I have no time to do anything at all. I don't eat, I don't.
Yep. All right. What time on the afternoon on April 23rd?
April, you name it, whatever.
I know, I am. I'm waiting for Ally to name it.
Oh. Yeah, look out for something, but I am.
We can do one.
Perfect.
Okay. All right, so now let's handle this probation violation here.
Your Honor, I would ask that this get adjourned that same day, as if we do have, we can do it all that one time. And if not, they can still handle it probation violation. But I think there's a big difference if he's pleading as well as the probation violation.
Well, I agree, and the court will note that this matter has been pending since 2023 because your client had failed to appear.
Correct.
So we will not hold the probation violation today. Sir, if you're to test right now, what's in your system?
Yeah.
All right, bond and conditions are continued. We'll see you back on both matters, April 23rd.
Great.
Careful driving out to Grand Rapids.
Thank you. Thanks for reminding me. Great to see you guys, and I'll see you in a little bit.
All right, thank you. All right, let's go off the record. Okay, Ms. Kraus, good morning.
Morning, Judge.
Okay, you are on Mr. Tunstall, correct?
That's correct. And I am also covering for Mr. Cripps today. I overheard you say he was supposed to be there in person.
Yes.
Okay.
He has to, all his matters are to be in person. He was over 3 hours late last week, so I'm not doing Zoom anymore for attorneys that don't get here timely, especially when we're tying up the Wayne County Jail camera. So, yes, so that's to be in person.
Okay, so I am covering for him today. I have a motion to argue at Third Circuit Court after I'm done with Mr. Tunstall's case. So is the court going to be available?
Well, we're available all day. I don't know how long your motion hearing is set. Because this was set for 10:15.
Right, and I was told it was by Zoom. My motion should not take any longer than a half hour.
You were told that it was by Zoom? Because I was very
Yes.
specific that it was in person.
That's
with
what I
Mr.
was told,
Cripps.
Judge.
All right, well, I believe Mr. Hicks is in custody. Is Mr. Hicks in custody, do we know?
I don't
Is your
believe he
client in
is.
custody?
No,
He's not?
no.
Oh, well, okay. So, well, I guess as long as since he's not in custody, we won't be tying up the wing on the camera. Just communicate with your client so that he knows that you're going to be late.
Okay, thank you, Judge.
Thank you. Okay. Mr. Rolak, good morning.
Morning, Your Honor. I have Mr.
Okay.
Hines.
Yes. All right. Do you need a breakout room with your client or with the prosecutor?
No, we are ready to go, Your Honor.
Did you already speak to the prosecutor?
I did.
Ms. Kraus?
Yes, Judge.
Did you already speak to the prosecutor on Mr.?
On Mr. Tunstall, yes, I did.
Okay. Is your client
He
here?
is on Zoom, Judge, yes.
Oh, there he is. Okay.
Judge. Yes. Could you ask Madison Mullins if an attorney has spoken to her throughout the week or?
Ms. Mullins?
No, ma'am, no one has spoken to me throughout the week.
Okay, there's your answer.
I'll get the file back to Laura so she can file.
Okay. It appears though Third Circuit Court did not send down, or their appointed services did not send anybody down. All right. Good morning, Mr. Mawad.
Good morning, Judge. Good morning.
Bobby, can you grab do you have the Tunstall file or do we have the Tunstall file back?
Is that Stalking?
Yes.
Okay.
Okay, that way Ms. Cross can get to her motion, hearing. Okay. Oh, also Hines too, Bobby.
I got Hines.
Oh, you have Hines, okay. All right. So Ms. Cross, we're just waiting on the file and then I can call your matter so you can get to your motion.
Thank you, Judge.
You're welcome. Meantime, we're going on the record in the matter of the state of Michigan versus Dakota Hines, 25241. And counsel, your appearance, please.
Good morning, Your Honor. Adam Wolak, number 55741, appearing on behalf of Dakota Hines, who is present on Zoom.
Let's go off the record. What's that?
I hope he votes.
Oh, okay. We're gonna go off the record for a moment as we're having some technical difficulties. Yes,
Mo said he turned in Tunstall.
I have Hines, yes. Not Tunstall. Do we have Tunstall?
He turned them both and.
Gentleman, he gets credit. Okay, thanks. Mr. Wolak, were you logged in earlier or did you just log in?
I've been logged
Judge,
in.
I
for a
logged
while.
in, I logged in earlier and I was talking to Mr. Mohammed, regarding Mr. Harvey's case, and he's a jailer.
Was that Mr. Wolak speaking or was that Mr. Mawad
No, that,
speaking?
Elias Mawad, Judge, regarding, Jared
Okay.
Harvey.
All right, thank you. Okay, thank you. I was speaking to Mr. Wolak. Okay,
I've been
Thank you,
logged
Judge.
in for a while, Judge.
I'm sorry.
I've been logged in for a while.
Okay.
I'm gonna run and see if the battery's up front because it keeps stopping. So you got it.
Okay. Alrighty.
About that.
Stevens.
Sorry about that one.
No worries. You're probably looking for a red file. Okay.
Good morning. Could I ask the court a question?
Good morning. Yes, Ms. Kavanaugh?
Good morning. I'm just making sure I was assigned to two matters. I believe they both have retained attorneys, but I'm just double checking. It is Ryan Stevens and Russell Sweetheart.
Well, I still show, so I show Ryan Stevens as Mr. Barry.
It looks like she's still up now.
And I still show you on Swihart.
Okay.
But we can double check the file to see if there's a substitution of attorney. Did you sign a substitution of attorney?
I didn't sign anything. I actually haven't heard from Mr. Swihart. It was Mr. Muhammad that let me know that he had retained an attorney. So I was just making sure all my.
Court's always the last to know everything, so that's something else. So we will double check to see if there's a substitution of attorney on that one.
Perfect. Thank you. I just wanted to make sure before I signed out.
Yes, thank you. Okay, so we're just in a little bit of a pause because we're having some technical issues right now. So I see Mr.
All right, well, they sort their tech issues. She's having a Monday here on a Thursday, I'll tell you. I think I said this in the chat. I think she's half a heartbeat away from blowing up, but I'll keep an eye. Let's go back to Judge Middleton. I believe he's doing a probation violation hearing.
Go. I'll call the case. This is People versus Robert Gray Baird. That's you, sir? Yes. Here with your lawyer, Ms. Jordan Harden. Also present as Assistant Prosecuting Attorney Abby Stoll. Defendant was charged with domestic violence or domestic assault for an incident that occurred on January 22nd of 2026. The defendant pled guilty to a domestic violence on March 5th. The prosecutor had recommended a deferral, and as I advised you at that time, I can only do the deferral if the prosecutor consents. We do dozens of them every year. The prosecutor has the discretion whether to allow the deferral or not. And the court can't do it unless the prosecutor agrees. So sometime between March 5th and our proposed sentence date of March 23rd, there came an alleged bond violation, alleging that you had violated the no contact and no assaultive behavior condition of your bond.
Your Honor, I apologize for interrupting. The alleged violation was February 5th. So it was well before.
All right, well, we found out about it before the sentence. Thank you. It actually occurred before the sentence. But anyway, it popped its head up at the time we were going to do the sentence on March 23rd. So we continued the matter further until today for sentence. Your lawyer and the prosecutor's office have been discussing this matter through the morning. As I understand our posture right now, Ms. Stoll, we're going to proceed with the domestic violence sentencing with the deferral allowed by the prosecutor, and we're not going to proceed on the bond violation. We'll simply proceed on a sentencing with a recommended deferral, where if the defendant completes the probation, the charge could be taken off his record. Is that the people's position?
That's correct, Your Honor.
You agree, Ms. Harden?
Yes, Your Honor.
All right, there was also a discussion of, for the continued peace of mind of the parties and the complainant, a tether, GPS tether, which would prohibit him from coming into physical contact with the complainant while we're on the probation. So, Mr. Baird, you pled guilty to the domestic violence charge. The prosecutor agrees with the deferral, which means I'm going to do a sentence which will allow you to take the charge off your record. I'm going to hang some jail over your head. If you violate the bond, you're just going to, if there's an allegation of a violation of the conditions, you'll go to jail and lose the deferral. Do you understand? You have to speak your answer.
Yes.
All right. Jordan, what would you like me to know?
Thank you, Your Honor. As the court is aware, the parties do have a minor and very minor child in common, so that does complicate things going further. I have discussed the benefits of the deferral with my client, as well as the expectations of him while on this probation in order to receive that benefit. He's aware, in my discussions with the prosecuting attorney, they are going to ask to continue with the no contact as well as a GPS tether to ensure there's no further inappropriate or assaultive conduct between the parties. We would ask that the current bond condition that allows my client telephonic or virtual communication for the purposes of talking about the needs of the child as well as parenting time with the child be continued. There is a domestic case in which he is awarded custodial rights and parenting time. So obviously that's something that he may need to navigate in the family court going forward. I have encouraged him to contact his domestic attorney and try to facilitate a third party to assist with that via court order to avoid any kind of confrontation or contact with the parties. He's aware the stakes are very high. If he is not able to comply, he loses not only the deferral, but potentially his employment, as the judge, the support will order him to do some jail time. So this is a case where the parties are extremely intertwined due to that child and their romantic history. So I have advised him that even if the complainant contacts him and tries to initiate contact with him, he needs to ignore her so that he can remain compliant and get the benefit of that deferral. Otherwise, we are in agreement with the conditions that the prosecution has asked for. We'd ask that any and all jail time be deferred as part of this deferral in order for him to receive the benefit. However, if the court feels that any upfront jail time would be necessary, we'd ask that it be scheduled by the probation department. He does not have any criminal history, no assaultive history. He's the type of individual for which this deferral was intended to help. So I would ask the court to afford him all the benefits and opportunities to complete that. Thank you.
Ms. Stoll, what's your position here?
Thank you, Your Honor. I've offered the domestic violence deferral so that the defendant can keep a clean record, hopefully learn from his mistakes so that he doesn't make them again. I would ask that the court order the most rigorous domestic violence probation possible as a way to help him learn from what he's done and move forward. I would also ask that, and the court's already indicated this, that the defendant be put on a GPS tether with hot zones around the victim's house and her place of work to keep him away from her. I understand that in cases of domestic violence deferrals that the court typically doesn't order upfront jail time, but I would like to see the defendant do a weekend in jail just so that he gets a taste of what it would be like if he were to violate his probation, so that he understands that the court's orders are serious.
All right. Ms. Shaw is here with the victim advocate. Do you wish to speak, or you just wish to be present? Is there anything you want to say? I'm willing to hear what you have to say. All right. Well, I'm glad you're here. Mr. Barrett, anything you want to tell me?
I'm very sorry for my actions. This is I've lost quite a bit of sleep on this. I've been really nervous about going through this. Even that one day in jail that I've already spent, that was
I counted it as 2. You got arrested late on the 22nd, and you early on the 22nd. You bonded late on the 23rd.
Well, that stay was a pretty good eye awakening, and this worry about bond conditions and the concern of not being able to be there for my kid or being able to pay the child support so they can be supported.
Where are you working?
Midwest Gutter Systems.
That's right.
Yeah.
Are you about to be real busy?
We're already real busy, and I've got
a lot of people got tornado guttered, but it's the time of year when your business picks up.
Yeah, I've got 5 straight days of estimates, 7-8 people a day that I'm meeting, plus weekend estimates most times.
Well, income is good to pay the support. This is always hard when the parties have a child together. These parties were not married, but they do have a case and counsel and parenting time and custody issues. So there is some family court supervision. The problem is you're stuck with each other for the next 17 years. And I don't do divorces. I never had any desire to be the domestic relations judge. God bless Judge Pattison. He wants to do that and he's very good at it, but it's very difficult. And sometimes there's no good answer. The best answer is bad for both parties. Makes Ms. Shaw's life complicated, makes your life complicated, makes the child's life complicated. But there's a public safety issue here. As your lawyer said, you've got no criminal record. The prosecutor mentioned it also. I'm gonna order 90 days jail, credit 2, giving 88 days to serve. You already did 2 days in jail. They have the 90 days, 88 are deferred. Usually in a deferral, the jail is deferred. However, if you violate the probation conditions, you could end up going to jail for 88 days. So my hope is that you'll comply with the conditions. I'm going to make the fine 0. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee. I'm doing a 12-month probation, which is $480. I need to pay for the class. I'm doing the full domestic violence class. I'm going to order community corrections GPS tether. No drugs and no alcohol. Ms. Shaw, I didn't get the impression that this was alcohol driven. Alcohol is not a factor in this matter. Is that correct? I didn't get that sense, but everybody that's on probation has this condition. And we'll do testing as directed if needed. You don't need drug counseling or treatment. All right, I forgot. You're in Vicksburg and you're in the Michigan Avenue house. So you're not really very far apart. No contact. Well, let's add that up. $125 plus $150 plus $480 plus the class, but that's $755 doing 1 year. I'm doing the full class. You're actually going to benefit from it. I never had anybody that took the class that didn't like it. They would say, well, I hate my wife. You're a jerk. My lawyer sold me out. I'll say, what'd you think of the class? Oh, I like the class. It's ironic. People that were mad about everything actually benefited and enjoyed the class. You need it for your relationships, for your parenting. No contact except for custody and visitation purposes.
Your Honor, does that extend to exchanges of the child if they were to meet at a public place like a police station? Okay, so he can have contact and exchange. For the
Well, my
purpose of
preference would be a third party.
I would encourage that as well.
I'm gonna, no.
Okay.
No contact except for custody and visitation virtually.
Okay.
Maybe it can go on, but it's gonna have to get better because this is terrible for your child. Even if you don't like each other, you need to deal with each other. The child support is a bad deal all the way around. I've said this a lot. It's not enough money for the mother to support the child, and it's too much money from the other paying parent. And in the middle is the child. It's a best answer to a bad problem. But
And again, I've encouraged him to contact his domestic attorney as soon as possible to try to get some third-party orders in place in that file.
and that could work. I commend you that you want to continue to be a part of your child's life. We have so many fathers primarily that just disappear because they don't want to pay. And they end up being a absent dad or a non-existent dad or a part-time dad that comes in long enough just to screw things up. But I'm serious. You guys need to work on it. You're going to go to this class, which is going to help you deal with these issues. You're going to be on this tether, which is going to keep you away from the complainant. And you got a bunch of jail hanging over your head. You got no criminal record, and if you can stay the course here, you won't have any. So we'll see how this goes. You can be discharged earlier than 12 months if you've completed all the obligations of the probation. So I'm gonna ask the court officer to take you out to the counter and we'll get you plugged into the probation.
Could I have him wait until the victim leaves?
Yes,
Thank
well, I
you.
was gonna have him go
Okay.
in there and then they can go out that way. So why don't you go ahead and escort him out to the counter. All right.
Thank you.
Mr. Baird, I want you to hold up your end of the deal. You need to, for your sake, her sake, and your child's sake. And I hope it works. You go with the court officer.
Thank you.
Thank you.
Okie dokie, friends. Let's head back to, well, at least I'm going to try to. Things got a little weird here. Hold on a minute. There we go. All right, let's go back to Judge DiSanto.
Donaldson, P number 53660. Here on behalf and standing next to Matthew Fisher, will you identify yourself, please?
Matthew Fisher.
All right, good morning. And today is the date scheduled for the adjourned probable cause conference in this matter. There was the plea needed to be circulated and signed by all parties.
That is correct, Your Honor. I think that last time we were here, you had some concerns about the initial plea offered by the people. That has since been revamped to, I believe, support you had. My client has signed and executed it. I signed and executed it, as well as the prosecutor, Mr. Mohammed.
Okay. All right. And sir, I'm going to have you please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. And counsel, if you'd like to place that resolution on the record?
Yes, Your Honor, if I may. Do you want me to specifically spell out the settlement offer or just?
Yes, please.
Okay. Your Honor, what we have entered into is an agreement that there would be a charge reduction by the people as to count one. My client will be pleading guilty to operating while intoxicated second offense. That was a reduced charge with a sentence agreement of 30 to 90 days jail as determined by the judge if the defendant does not enter into a specialty court. This jail condition may be waived at the discretion of the court if the defendant completes a specialty court program pursuant to MCL 257-6259 B and or C. The drunk driving third charge will be dismissed at sentencing, provided the terms of this agreement are satisfied. The judge can impose jail at its discretion and any other sentence term. The sentence agreement is for 2 years probation with sobriety, drug, veterans, mental health court that the defendant will need to find placement on or before sentencing. No early termination of probation or modification of the sentence may be made unless the defendant successfully completes a specialty court. Any scale approved sobriety or specialty court will be acceptable. The 27th District Court has an acceptable program.
In addition, all other terms set by the court cost the prosecution of a minimum of $500 or more as determined in alcohol, drug screening and treatment. Full restitution for any out-of-pocket costs for damages or harm incurred because of the offense on or before sentencing, if applicable. If the defendant is terminated from the sobriety or specialty court due to continued program violations, commits another crime while on probation, including a license or traffic crime, or the judge finds sufficient cause to terminate probation due to the continued violations, then the balance of the year must be served in jail, no work release or waiver, which is non-discretionary with the court. And above violation can be grounds also to vacate the OWI second plea agreement. The defendant will stipulate that the sentence agreement and third OWI offense are sufficient grounds for incarceration if it's imposed. The judge may accept all the terms, the judge must accept all the terms, and the only offer is only open while the case is pending in the district court.
Okay,
And he's also signed and executed the standard advice of rights form that's attached.
yes, as well as the, this plea agreement, as you indicated. One, just clarification, so it indicates the OWI 3 charge will be dismissed at sentencing provided the terms of the agreement are satisfied. Just so you know, counsel, once the plea is accepted, then the clerks do their data entry and, reduce the charge. Then it technically dismisses the OWI 3rd. So just so everybody's on the same page, in the event your client does not satisfy the terms of the agreement, then the people can request to have this plea set aside and the court will grant it because the way everything has to be inputted, it dismisses the charge. I don't have any control over that part of it. It's all a computer.
And I've explained it to my client in terms of going through this pretty much in depth. So I think he has a good understanding, especially supplemented by your comments as well.
Okay, thank you. All right, and so Mr. Fisher, you heard all of the terms of that agreement that you've gone over with your attorney and you've signed the document, correct?
Yes, Your Honor.
And as to the amended charge of OWI operating while intoxicated second offense, how do you plead?
Guilty, Your Honor.
You've gone over your advice of rights as you've already, your attorney's already indicated, and you've signed this document, correct?
Yes, Your Honor.
And you understand all of those rights.
Yes, Your Honor.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, Your Honor.
You understand as well, sir, that the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes, Your Honor.
And you also understand the requirement in your agreement to participate in sobriety court if you're eligible.
Yes, Your Honor.
And counsel, I believe that you were working with 25th District Court because you had requested probation to send the lien over to 25th District Court.
That's correct. Natalie from your office contacted Ms. Mendenhall, who is the chief probation officer. So we actually went over there the last time we were in court. I physically took my client. They can't process the file until after May 1st from what she's indicated to me. So
Okay.
just wanted to make the court clear of that because of logistics with a vacation and one of their staff, their daughter is having a child and she's leaving the office for a short period of time. So I just wanted to make that clear to the court that it's through no fault of our own that delayed. Thank you.
Right, okay. And so, sir, knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Any immigration issues?
No, Your Honor.
Counsel, if you can please voir dire your client.
Yes, sir. On or about February 1st, 2026, in the city of Wayne, the city of Wyandotte, county of Wayne, were you operating a motor vehicle on a public road?
Yes.
Prior to operating that vehicle on the public road that particular day, had you consumed alcohol? What type of alcohol and how much?
I'll take Dr. Jameson whiskey and I'm drinking beer.
Okay. Do you know how many beers and how many shots, if you can recall?
Quite a few shots and quite a few beers.
Okay. Did the alcohol impair your ability to operate that motor vehicle?
Yes.
And were you stopped by a Wyandotte police officer?
Yes.
And what was the basis of that stop?
Basis stop was all speedy.
Okay. And after that, you did some field sobriety tests?
Yes.
And you actually also did a chemical test where there was a blood draw relative to collecting blood to determine your blood alcohol level?
Yes.
And would you agree that that amount was above a 0.08?
Yes.
I'm satisfied with the plea.
All right, thank you. And for purposes of the plea, counsel, are you stipulating to the level of?
We would stipulate that the tox report, as it relates to this case, came back from MSP as a 0.21.
Okay, all right. The court is satisfied. The plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge based upon the terms that were placed on the record regarding this plea agreement. So counsel, when you go over to probation, just remind them that he's being screened and likely eligible for the 25th District Court sobriety court so they can set the sentencing after May 1st.
Thank you.
Doesn't make sense for you to come back beforehand before you can be screened. All right. And so Mr. Fisher, we amended your alcohol tether to SoberLink, and so you're still testing with that, correct?
Yes, Your Honor.
All right, don't show any violations. And so if you were to test today, anything that's not prescribed in your system?
No, Your Honor.
All right, bond and conditions are continued. Please have a seat in probation. Somebody will be with you shortly.
Thank you, Your Honor.
Thank you.
So I'm not going to show it because the whole interaction was only about 30 seconds. However, I did just see a cool thing over in Judge Boyd's court. A defense attorney had 2 young student attorneys with him for their first time in court, and it was just a quick dismissal, so very super quick hearing. But Judge Boyd had those 2 student attorneys put their names on the record, and then she instructed her clerk to give each of them printouts of that hearing so that they could frame it and have it as a keepsake. So I just thought that was really cool of her to take the time to do that. Anywho, let's go to Texas, though, not Judge Boyd, but Judge Stevens.
Here, right there. You can see he's here. That's Mr. Cartridge. Mr. Cartridge. Yes, sir. All right. Go ahead, Jeremy.
And so that arrest in Dallas County from back in September, that Dallas County case has still not been filed, much less indicted. My client, he is a resident of North Texas up here in Collin County or Denton County. He's working in Dallas. And like I said, you know, he drove all the way down to Jefferson County just to turn himself in and take care of this warrant. He's not going to have any problems showing up for court. He hasn't had any problems.
What happened on October 9th?
On October the 9th, what happened there
He failed to appear. Right.
So Judge, on October the 8th, I contacted Robert Menard of the Jefferson County Community Supervisions Department and talked to him about this issue. And I said, hey, what's going on? He said, man, you know, a motion to adjudicate is going to end up coming. I said, well, why would we drive all the way down there for us to tell you that, yes, he did get arrested and we know that a motion to adjudicate is coming? Why don't you just tell him that we contacted you, tell him that we made the cost benefit analysis to say that we're not going to drive 12 hours and go ahead and issue the motion to adjudicate. And whenever that happens, we'll turn ourselves in, which is where we're at.
Well, y'all are setting the standards and the rules, not me or the rules. The rules are already in place. No matter what happens until he gets arrested, which didn't even happen until after January, right? I mean, this thing was filed January 2nd and he's not showing up on October 9th, 3 months. I mean, yeah, if I tell, this is what I've said for 20 years. If you can't do anything on probation, you got to show up, or else you're on your own probation, not ours. It's just, you got to report timely and regularly, or else we're unable to supervise you. And that's one of the allegations. That's always important. If you don't show up, you're not on really probation. You're on your probation, which in the way, that's tail wagging the dog. That's just not the way it should be. But it's still not a good idea at all to violate the very first condition, which is don't commit a crime. But what are we asking for today?
Judge, I'm just asking for a bond. His original bond back in 2023 was $5,000. It's usually double the bond is normally what I've seen on these things. And
not here. I mean, there is no standard for that here. I mean, it depends on what the circumstances are. I know it's double. State is here. Mr. Laird and the probation officer is also here. So if you need to communicate with them, you're free to. Mr. Laird, on behalf of the state, I think he's entitled to a bond.
Yes, sir. He's entitled to a bond, and I cannot comment on the new offense in Dallas County. I don't have the new offense material. It hadn't been filed yet over there, so I do know that
It's a state jail felony.
It's a,
what they're
yes,
saying. So
yes, sir. If he does have
it's not
something,
violent crime.
I'd ask that he have a GPS put on so that we know that he's not frequenting places that might have solicitation.
Where are you going to live if you are released?
I have my own place, sir, in Louisville, Texas.
And where?
Louisville, Texas.
Louisville.
8801 Hebron Parkway.
Okay. All right.
And it's right next to my job.
Okay. From probation, anything we ought to talk about that we're not talking about that is related to his probation? All right. What are you asking for, Jeremy? How much?
A $10,000 bond, Judge.
But you said 5,000.
Well, 5,000 was the original one from 2023.
Okay. Well, here's what we're going to do: 7,500. Okay, I'm going to order a bond for 7,500. Plus, you're going to have a GPS device on you so we know where you are, so that when you're not reporting, we know where you are.
Yes, sir.
And is there any? Are you asking for home confinement on this?
No, sir. No,
I don't
that's
think
not the.
that's necessary under these circumstances. Okay, so if you post a bond, you get out of here. What are you going to do during the day?
I have a job, sir. I'm
What do you do?
Internet manager at Plymouth Chevrolet since the fall of 23. So coming up with.
So what are you doing here? You got a responsible job.
Yes.
And responsibility to a family, I guess. Fix this.
Yes.
Fix it.
The past 6 months I've been in therapy for it, and I also going to church and got a Bible study and found Christ.
How's that working?
Amazing.
Oh, good.
I also got a divorce, and it's been
How's that working?
amazing. We're great co-parents. we were in a visible marriage.
Oh, okay.
And I found God in the church. I go to Bible study every Wednesday, and I see my therapist every Monday. And I'm an award-winning car salesman, doing my best to stay out of jail. I know I made a mistake.
Well, it's fixable. That's the test of character. Everybody makes a mistake. Everyone in here has made a mistake. Defendants and other. It's how you fix your mistake. That's the test. Are you going to fix it? Well, and responsible? Good. And that's the test of character. Okay. All right. Do better. And that's going to be the order of the court. Next event is he'll post a bond. He'll get out. We're going to have an announcement?
Yes, sir. So they get time to see what's going on with Dallas.
Ellie is one of my coordinators. She'll send you something on the next event here.
Yes, Your Honor.
Okay. Anything else?
I don't just want on the GPS, Judge. Is there any way we can have that monitored? He reports up in Collin County every month. Is there any way we can get Collin County to maintain that GPS?
I don't know how they do that. We've always done it because I never thought another probation officer.
Usually the bonding company kind of keeps an eye on things, and if there's an issue, then we all look at it and see what's going on where he is.
Okay. So just as long as he keeps it charged up, we'll be good.
Yes, sir.
Okay, that sounds great.
Don't lose the charge on it. Sometimes it bleeds out fast, but keep the charge so that because if it discharges, then there'll be an alarm that'll be set off of where are you? Where's Waldo?
And you're talking about work because I don't. Arsenal's on there.
No, I think it's chargeable.
8 to 8 usually.
Yeah, I'm sure.
And he doesn't have to wear it while it's being charged, is it? Does he?
Yeah.
Does he?
It's.
Okay. I do it at night.
I think I believe it's staying.
I think, don't they do it at night, Jen?
Yes, yeah, I mean, it should look like all day.
How long does it take to charge that?
Like all day sleep, so. They just have.
Takes a few hours. Do it at night when, yeah, it's a pain. Just don't walk in your sleep.
Yes, Your Honor.
A long way. Oh, okay. We'll get a resetting to everybody. Okay. Thanks.
Thank you, Judge.
Thank you. Yes, sir.
All right, let's head back up to Michigan, Ingham County this time, and one of our new favorites, Judge Acalina.
251162 FH, people of the state of Michigan versus, is it Regina?
No, then you're on.
Oh, this is I'm sorry.
This is Alberto.
Okay, it looked like a Regina. All right, well, let me get back on his file now. This is docket 25288 FT, people of the state of Michigan versus Alberto Herrera Perez. Counsel, your appearance for the record.
Good morning, Your Honor. AP Bart Buxton on behalf of the people of the state of Michigan.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Alberto Perez, who is standing to my right.
All right, sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. I put your hand down. And sir, you're taking any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
Yeah, but I'm not taking.
Okay, so by not being on medication, does that interfere with your ability to understand the court or your attorney?
No.
All right, so you're feeling fine today, sir?
Yes.
Have you had no time to speak with your attorney?
Yeah.
All right, and I understand this is going to be a plea today, is that correct?
Yeah.
And do you still live on Waverly Road?
No, Your Honor, he has an address that we've listed on Rysdale.
Okay, I do see that. Okay, we'll make sure that gets into the computer. And who do you live with, sir? Who do you live with?
Oh, my girlfriend.
Okay.
Daughter.
And are you employed?
Oh, not right now.
Okay. So is she helping support you?
Yeah, my brother does. He owns a towing company.
You own a?
No, my brother.
Can you repeat that?
He owns a towing company.
Towing.
Okay, and what's a towing company?
What brother?
And so is she helping to support you? And he said yes,
No,
and that.
I said no. My
No.
brother.
Your brother is?
Yeah.
Okay, got it.
Okay.
Okay, so you're going to be pleading today. Were you on probation, parole, or bond conditions on another file?
No.
No? Okay. And are you a US citizen?
Yeah.
On behalf of the people who has the plea agreement?
Yes, Your Honor. The defendant will be pleading to count 1, police officer fleeing in the 3rd degree. Upon successful plea and sentencing, count 2, resisting obstructing a police officer, and the habitual 4th offender status will be dismissed. There is also a kill agreement to 12 months upfront.
To serving 12 months up front?
12 months jail.
Cap, so a county cap.
Yes.
Okay. All right. Is that full, fair, accurate, and complete?
Yes.
All right, and you're waiving count 2 and the habitual 4th?
Yes.
As to count 1.
Yes, Your Honor. People of the state of Michigan versus Alberto Herrera Perez, State of Michigan, County of Ingham, in the name of the people of the state of Michigan. The prosecuting attorney for this county appeared before the court and informs the court that on the date and at the location described below, the defendant in count 1, police officer fleeing 3rd degree vehicle code. On or about January 31st, 2025, at North Martin Luther King / West Oakland, Lansing, Michigan, 48915, Ingham County, State of Michigan, the defendant being the driver of a motor vehicle to whom was given a visual or audible signal by hand, voice, emergency light, or siren by Jake Ellis, a police officer who was in full uniform, and the officer's vehicle was identified as an official police vehicle, acting in the lawful performance of his/her duty, directing the defendant to bring his/her motor vehicle to a stop, did willfully fail to obey that direction by attempting to flee or elude that officer in an area where the speed limit was 35 miles per hour or less, contrary to statute. This is a felony that's punishable up to 5 years and or $1,000. The Secretary of State shall suspend the license for 1 year, per MCL 257.319. Court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition, if not taken time of arrest, and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yeah.
So you understand count 1, police officer fleeing 3rd degree under the motor vehicle code is a felony punishable by 5 years and or $1,000, and the Secretary of State shall suspend your license for 1 year.
Yeah.
And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yeah.
Did you understand what you read?
Yeah,
And if you had any questions, your attorney was able to answer those?
yeah.
As to count one, police officer fleeing under the motor vehicle code, 3rd degree, how do you plead?
Yeah. Yeah,
I'd say out loud.
yeah.
You're changing your plea from not guilty, are you changing it to?
Guilty, no?
Yeah.
Guilty, okay. And sir, did anyone force, threaten, or coerce you plea?
No.
Did anyone promise you anything that caused you to plead? And you understand you have to tell me that now, because if you tell me that later that you shouldn't have pled, I don't have to allow you to withdraw your plea.
Yeah.
And you decided to plead after you spoke with your attorney?
Yeah.
And you've been satisfied with the representation of your attorney?
Yeah.
And do you understand that if you choose to appeal now, you first have to ask permission of the Court of Appeals to appeal, and if you've gone to trial, then you would have an automatic right to request an appeal and have that be granted, but now it becomes a decision of the Court of Appeals. Do you understand that?
Yeah.
Now, if you violate the law or bond conditions between now and sentencing, I do not have to honor the county cap. I could send you to prison if I wanted. However, if you honor everything and I did more than the county cap, I would allow you to withdraw your plea and this matter would again go to the pretrial stage. Do you understand that?
Yeah.
Okay. Did anyone tell you what I will do at sentencing other than the plea agreement?
She's just asking if we've talked about anything that she might sentence you to definitively at sentencing. Have I said that she has said what she will do at sentencing yet?
No.
And that's because I don't know. I'll make up my mind at sentencing. Do you understand?
Yeah.
Okay. Now, sir, did this offense occur on or about January 31st, 2025?
Yeah.
In the city of Lansing County, of the state of Michigan?
Yeah.
At a specific location known as North Martin Luther King and West Oakland, you came in contact with law enforcement?
Yeah.
And you were driving a motor vehicle?
Yeah.
And you saw the police with their sirens in a marked uniform and marked vehicle?
Yeah.
And you knew that you were supposed to stop because they were acting in their official capacity and you failed to stop, is that correct?
Yeah.
Did you take off or go in a different direction than they told you to?
Well, I never took off. I just not stopping right away.
You just didn't stop?
Right away, yeah.
Okay, did you eventually stop?
Yeah.
Okay, but you should have stopped a lot sooner?
Yeah.
And you were continuing to go forward without stopping, trying to elude them?
No.
Counsel?
I would say, did you, like you said, Mr. Perez, you were in an area where, like in a residential area, like, you were going home, right?
Yeah.
And the street was less than 30, the miles per hour, the speed limit was less than 35 miles per hour, right? And you were being directed to stop your vehicle, correct?
Mm-hmm.
And
Is that a yes?
Yes.
And you did not stop it, correct?
Yeah.
Now, you didn't necessarily speed up, correct? But you did not slow down or stop.
Yeah.
You continued until you got home, right?
Yeah.
All right. And so do you agree that you were disobeying, you were attempting to flee?
Okay, yeah.
Your Honor, I believe that's all I can get.
On behalf of the people,
The people are satisfied, Your Honor.
our counsel will promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No.
As court complied with courtroom.
You have, Your Honor.
Yes.
Sir, how far did you drive once you saw, or maybe you can answer that, counsel, is it in the police report?
It is in the police report, Your Honor.
I mean, was it just a few blocks to his house or was
Yeah.
it longer?
It was, the traffic stop started on, while they were traveling west on Saginaw Highway. His street I would say would be about 6 or 7 blocks. Or less than that, before he turned onto his street and then pulled it and then continued to his driveway.
Okay. I find defendant's plea has been freely, voluntarily, knowingly and understandingly made without undue influence, threats, coercion, or promises of leniency. Has the court complied with court rule?
You have, Your Honor.
Yes.
And I also find there are sufficient grounds to accept defendant's plea given the full circumstances. Therefore, count 1 will enter count 2, and the habitual 4th are dismissed in their entirety. Any outstanding warrants, if any, related to this file are also recalled and dismissed. Do you have a sentencing date?
June 17th at 10:30.
Does that meet with your schedule?
That's fine, Your Honor, thank you.
All right, sir, you need to make and keep an appointment with probation. You should probably go down now. Otherwise, you can call them. The number is 483-6100. It's on the purple sheet, but we can't go to sentencing without that pre-sentence investigation report. So please go downstairs and make and keep that appointment. Bond and bond conditions are continued. Anything else we need?
No, Your Honor.
No, thank you.
All right, thank you. That's all.
Yep.
TCF Live entering hour 3 on this Thursday. I hope you're all having fun so far. I know I am. Let's go to Louisiana. Say good morning to the board.
It's 8:49. The date today is the 9th day of April, 2026. We're at the Department of Corrections headquarters in Baton Rouge. The panel today consists of, to my left is Danny Barra, to my right is Pete Freeman, and my name is Steve Frater. We're going to be conducting parole hearings and parole revocation hearings this morning from this location to a number of different locations throughout the state. Staff, would you introduce yourselves, please?
Whitney Trustler.
Okay, thank you. Our first place that we'll be going is to Webster Bayou Dorchette, and it's a revocation hearing against Mr. Eddie Robinson. Is that you I'm looking at, Mr. Robinson?
Yes, sir.
Okay, and Deputy, would you introduce yourself, please?
Yes, sir. It's Major Culpepper.
Okay, thank you, Major. Appreciate that. Appreciate that. And let's see, Mr. Robinson, would you give us your DOC number, please?
414-582.
Okay, and your case is being handled by Mr. Barra, and he's going to be going over the your form that you signed and all that sort of thing with you, and make sure that you're ready for this hearing, and then we're going to have the hearing. So, Mr. Barra, it's yours to call.
All right, Mr. Robinson, I'm reviewing your summary of your preliminary hearing held with probation and parole, and it looks like they determined that you were not eligible for appointed counsel. So we're going to go ahead and proceed without appointed counsel. Have you hired a counsel to be with you?
No, sir. I was still waiting on the duration of the case. I don't think I need a counsel. I was just waiting until the charges, till I got them dismissed or whatever.
Okay, well, it looks like that haven't got that far yet, but we're going to review the case anyway and see if you have violated, because the conviction is not the violation. The criminal behavior is what the violation would be.
Okay.
So we don't have to have that conviction. So let's start out. It's alleged that you have violated condition number 2 of your parole, that you submit monthly reports by the 5th of every month until you complete your supervision. You also report to the parole officer when directed to do so. Officer Blanchard read the violation and stated that you have failed to report for the months of October, November, December in 2024, and also in 2025, you failed to report for January, February, May, and June. Also, that parolee Robinson pled guilty and stated he was scared to report because he was using drugs and was afraid he would be put back in jail.
Yes, sir.
Is that still your statement today?
Yes, sir. Yes, sir.
All right. Then the second violation is a violation of condition number 4. Says you're not engaged in criminal activity nor will associate with persons known to have been involved in criminal activity. You will avoid bars and casinos and will refrain from illegal use of drugs and alcohol. Parole officer reports that on 6/13/25, you were arrested for the offense of home invasion, domestic battery by strangulation, and domestic abuse battery with child endangerment. What do you have to say about that charge?
Those are the current charges that I'm still fighting right now. I'm innocent of those charges. That's the reason they are still ongoing, because I was going to take those matters to trial. The other March 30th, when I went to court, the DA had came up with a plea offer, a 3 more year probation, but I didn't get to hear it fluently while I was at court. So they set the matter out to May the 4th, because I was willing to fight those charges because I was innocent of all those charges. And I'm only fighting one charge of home invasion, the domestic abuse battery and the child endangerment. I'm no longer fighting those charges. I'm only fighting one charge, home invasion. I'm innocent of the charge, and I'm currently going to court on that matter, sir.
I see that that's also part of the file that the victim assistance coordinator memo says the DA only charged you with the home invasion and was and has pending court date of May 4th.
Yes, sir.
The victim in the domestic abuse charges and the child endangerment, they were unable to locate, didn't respond to the letters. Okay, so it looks like evidence was presented by Officer Blanchard in the form of a police report for the home invasion, and it says Officer Trevor Sashery stated that on May 23rd, 25, he was dispatched to 1207 3rd Street in Springfield, reference to a domestic disturbance in progress. As Officer Sashery made his right-hand turn onto 3rd Street, he observed a gray sedan to be traveling at a high rate of speed. Officers were then informed by the caller that the victim and the suspect were in the gray sedan and that the male subject forced the victim into the vehicle by her throat. After finding out this information, Officers Sashery began attempting to catch up with the vehicle, Officer Rodriguez and Officer Rodriguez. Officers reached speeds of 95 miles an hour trying to regain a visual on the vehicle, which was now southbound on Arkansas Street. Officer Sashery approached the vehicle. He noticed that the vehicle was occupied by a white female operator along with 3 small children. Officer Sashery approached the vehicle and spoke with the operator, who was identified as Shayna Smith Lewis. Shayna advised that she had been involved in a disturbance on 3rd Street with Eddie Robinson and that he had punched her in the face. Shayna stated that she did not remember much of the incident due to everything going white when she got hit, but stated that she did not think that he had choked her. When asked Shayna where Robinson was, she stated he had jumped out the vehicle near the railroad tracks and ran to the area, therefore explaining why the vehicle came to a sudden stop on Arkansas Street. Shayna stated that when Robinson saw the blue lights approaching, that he told her, "Let me out," and began crawling over her son, Bryson. While speaking with Shayna, officers noticed Shayna to have difficulty speaking due to her voice sounding raspy and sounding as if she could barely speak. Shayna had swelling on her face and had a hard time speaking, so officers called EMS to check her out. Officer Sashery spoke with Shayna's daughter, Jacelyn Lewis, who was seated in the right passenger seat, and asked her if she knew what happened. Jacelyn stated that they were at her mom's friend's house when the man showed up and began yelling at her mom and hitting her in the face. Jason stated that the man then yelled at mom to get in the car and drive. But then the man jumped out the car and ran into the woods back there, pointing toward the railroad track. When asked, Shayna stated that she did not wish to press charges, but was advised by Spring Hill Police Department they would be picking up the charges on behalf of the state. Officers then went and got a witness statement from Janice Nipper. Janice Nipper stated that Shayna and her children were visiting when Robinson suddenly entered the residence without permission and knocking. Once inside the residence, Robinson cornered Shayna and began screaming at her before he punched Shayna with a closed fist in the face. Napier stated that the following this Robinson forced Shayna into the vehicle and screamed at her to drive. Nipper stated that Robinson was seated in the back seat on the driver's side and was holding Shayna by the neck as they departed the scene before the officers arrived. Nipper stated that she wished to press charges against Robinson for coming into her residence, stating that Robinson has been repeatedly told not to come to her residence and has not been invited to come over on the night of the incident. The police issued warrants for Robinson. So that's the evidence we have. We'll listen to you and see what you got to say.
Those charges were completely blew out of proportion by Ms. Janice Nichols. And she have contacted the DA with that she don't wish to pursue these charges, and that's currently what I'm going through right now in the court. That's what I'm going back May the 4th for. Hopefully get a dismissal of all these charges. I'm innocent of these charges. I didn't do it. The only thing that's true in there is that Shayna let me out the car because she told me Ms. Janice blew it out of proportion and had called the police for me to leave the resident. The other stuff, I didn't do none of the other stuff, and I'm going to court right now to prove that I'm innocent of everything that was presented in those police reports.
So you're saying that kid lied? 8-year-old kid?
I'm saying that the kid said that I punched Shayna in the face repeatedly. And Ms. Janice and Shayna said I only punched her one time with a closed fist. I'm saying that Ms. Janice told the kids in the house what to say. Shayna is the one that said, let's leave here because Ms. Janice called the police. I'm saying that everything in that police report, outside of me jumping out of the car because Shayna told me that the police were called, are not true. And that's the reason, and the charges are not, Shayna refused to press charges from the time that. Yes, sir.
That does not matter. Did you go into Miss Nipper's house?
Oh, I was already there. I had been there all day. The charges are frivolous. You know, she asked me to leave, but I did not go into her house unauthorized, and I did not go in her house forcefully. I had been there all day. We was all in there using drugs. Those accounts did not happen. I did not punch her in the face. I did not do that with the kids. I told my PO, the only reason I didn't report is because we had been under the influence of methamphetamine I was using, and I felt like it was proper for me to come to jail because I had needed help with getting off drugs. I wrote the DA and I told the district attorney the account of what had happened too. It was a misunderstanding in the house while I was already in the house, but a home invasion and an unauthorized, sir, I did not do.
So it looks like everybody, Miss Nipper, Miss Shayna, the daughter, the police, everybody's lying, and the only one telling the truth is you, but you want drugs. So how do you remember what's true?
We was all on drugs. I'm saying I'm still of a sound mind. We was all on drugs. Me, Mr. Nils, and Shayna, we was all using drugs, and the kids were not in there to even see what happened in the room. It was just me, Miss Janice, and Shayna in a room by ourselves. That's what went on. The kids were not even in the room to even see if anything went on or not go on. I'm saying that Ms. Janice has contacted the DA to let them know that it was a misunderstanding. And when she told me to leave, the only reason she called the police, she told me to leave. That was the problem, not me jumping on the lady in front of kids. I got kids. I never ever once been to jail for domestic abuse. And this is not my old lady or nothing like this. We was all just friends getting high. The real situation was behind me telling
Let me interrupt you for just a second. We seen one of my favorite verses in the Bible is that gagging on a gnat and swallowing a camel. That's what we keep talking about, this domestic abuse, but you telling me that y'all was all in there doing meth and you're on parole?
Look, I needed help. I'm not the only parolee that's using drugs. I'm telling you the truth of the account.
Okay, I appreciate it. That's just all I wanted to know.
I'm just telling you the truth of what was going on. If anything, I needed some rehab, but I did not do a home invasion or none of that. I'm telling you the truth. Yes, I'm telling you that we was all in the house.
Let's move on.
I got one last question. Why run if you're innocent?
Sir.
I've never ran when I was innocent. I did a lot of bad things when I was young.
And you're right. I understand exactly what you're saying. But I was let out the car before it was even a police even on the thing. Shayna told me when we left the house. Me and Shayna left the house with her. She told me that I think Miss Denise called the police, so the police gonna be coming. She let me out the car. It wasn't no climbing over there or running out when it wasn't none of that. She let me out the car, and that's what it was.
I got one final question. How did you expect you'd ever get help if you wasn't gonna report to the parole officer?
Because I was in denial, sir. I needed help. My mom had been telling me I needed help, you know, and I did. You know, my parole officer even told me if you need anything or, you know, come talk to me. But I was in denial, you know, pride, you know, kind of was in the way like I was figuring I could do it by myself. Like I had the thing figured out, just like, you know, my fiance is on camera. You know, pride had got in the way. I thought I could do it on my own and get off on my own, but I couldn't.
All right, thank you. I'll move for executive session.
You want to call Jennifer McCutcheon first?
Did you want to talk there? Oh, okay, never mind. I don't need executive session. I thought it was an executive session. No. All right, we'll call for testimony from Miss Jennifer McCutcheon.
Yes, sir.
All right, tell us what you know about this situation.
I do know that Eddie was, you know, having a problem with meth. He was having a problem with meth, and over there, you know, Miss Nippers has the house, and she's basically a lonely older woman that invites younger people over to do drugs. I don't do drugs. I understand. So she invites these people over to hang out and do drugs so she's not bored. And, you know, Eddie was not a meth user prior to him getting out of jail this last time. And, you know, he just met this Shayna girl, and she's been a user for a long time. And I think she was just trying to find somebody to, you know, that interests her to do it with. And unfortunately, Eddie got caught up in that. And I know that he was not used to that stuff, and he, you know, it wasn't good for him. So he did a lot of stupid stuff. But I believe now that he, you know, has his mind together and wants to definitely not go down that road again. And that's pretty much what I know about it.
All right, thank you for your testimony.
Thank you, sir.
Anybody else has a question? No, sir. All right, Mr. Robinson, I think we've heard enough of this one. It's basically you absconded supervision because you were on drugs. You admit that. You continued to use drugs while you were on parole, and you're a fifth offender, so I'm sure you had several periods of parole before to know that this is illegal and not approved. And For those simple reasons, I have no choice but to revoke your parole. I'm gonna order them to put you in some drug treatment while you're in there, so that when you get out, you'll be all right.
Yes, sir. Yes, sir. I agree with it.
Can't get help if you don't go ask, you know what I mean?
Right, I need it. I'm saying I don't got a problem with this decision at all. I need it. I got a son at home that just born 6 months. I need all that I can help to be the best version of myself for my fiance and my son and family. So I think this was a proper decision made.
But you gotta ask for it and agree to it. You know, I can order it, but if you don't want to take it, they're not gonna.
I want
it. Do y'all have the treatment there at that facility?
Yes, sir, or else they'll be moved over to Bossier, one of the two.
Move him if you have to, but we want to get him into the treatment as soon as we can.
Yes, sir.
Yes,
Thank
sir.
you. Go.
Yeah, I vote. I find that he violated condition number 4 of his probation, order to revoke.
Okay, and I concur in violate motion, numbers 2 and.
The probation approved.
And we all concur with the recommendation of drug treatment.
All right, good luck to you. Hopefully you can fix that problem.
End of this hearing, 9:08, you are revoked.
Thank you.
Revoked to the surprise of absolutely no one. Let's go to Texas, Judge Boyd.
0000641. State versus Jesse Ramirez. Can I have parties announced?
Mr. President, for the state.
Robert Brabant, Jesse Ramirez.
Are you Mr. Ramirez? Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. Ramirez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, ma'am, I do.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Ramirez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Charge of possession of a controlled substance, penalty group 1B, 4 to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you. You will be allowed to withdraw your. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. No gum chewing. Sure. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he's mentally competent.
Mr. Ramirez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a $1,200 fine. State recommends deferred adjudication. There's fees of $120 to the Bexar County Crime Lab for the drug testing. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, ma'am.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No motion, Judge.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 6 years. There be a TAP evaluation, 120 hours of community service restitution, the DOEP course, parenting class, and regular random UAs. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, state offer states exhibit 1 in all attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
If you're drug tested today, what are the results going to be?
Negative.
All right, so why are you driving around with children in a vehicle and there are drugs in the vehicle?
It was a stupid mistake.
I'm sorry, I can't understand you.
It was a bad decision, and I honestly don't know why I was doing it.
So why, what drugs have you used in the past?
It's marijuana.
And do these children live with you?
Yes, ma'am.
And who else lives with you?
My wife.
And is she using?
Oh, ma'am.
Are you employed?
Yes, ma'am.
What do you do?
I do residential solar. I'm a residential solar installer.
Okay. All right, this is what the court is going to do. Court is going to sentence you to 6 years deferred adjudication. There's a $1,200 fine that will be probated. Proof of employment within 45 days. No employment as a home health care provider or with minors. There is $120 restitution to the Bexar County Crime Lab for drug testing. Regular reporting by Zoom or in person. Regular random UAs or the patch. $200 hours of community service restitution. I'm going to order parenting classes. Once the parenting classes are complete, 100 hours will be deemed satisfied. The remaining hours, the court will deduct 1 hour for every sober support meeting completed. There's to be a TAP evaluation. Out of custody, follow recommendations. There's going to be field visits 1 time per month until further notice. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
It's where I can do the drug tests, where I can be able to do it.
Oh, what's going to end up happening? They're going to do a TAP evaluation. So the TAP evaluation will let us know what issues you may have
Yes, ma'am.
and whether or not you need to take a drug class.
Thank you, ma'am.
All right. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. When you have young children, if you're using drugs around them and they're smelling it, that's not good for them. They are growing. Their brains are growing. Everything about them is growing. and they're taking notice of everything. And if you're using drugs around them, that tells them that it's okay to use drugs. You understand?
Yes, ma'am.
And I don't think you want that for your children.
No, ma'am.
All right, good luck to you.
Thank you, Judge.
You're welcome.
All right, friends, let's head back up to Michigan, pay another visit to Judge Acalina. Reminder, in about a half an hour, we'll finish up yesterday's pieces of the pretrial that we were watching, or preliminary exam.
This is docket 25-5598 FH, People of the State of Michigan versus Mohammed Idris Perkins. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Your Honor, Fred Blackman on behalf of Mr. Perkins, may I approach?
You may. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
All right, thank you. Put your hand up. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you had enough time to speak with Mr. Blackman?
Yes.
I understand there's going to be a plea today, is that correct?
Yes, ma'am.
And do you still live on Chestnut?
No, ma'am.
All right, do we have your new address? Is it on the advice rights form?
Yes, I put April, I think it's April.
Oh, April?
Yeah,
Okay, I do
April.
have that, okay. I have that on different forms, so you must have provided it before. Okay, and were you on probation, parole, or bond conditions at the time of this offense?
Yes.
And that was probation with me?
Yes.
Anybody else?
No.
Will this result in a probation violation? Or are they
It
taking
is,
care of
and part of the resolution is on the probation violation, we run both sentences concurrent, and not one not to exceed the other.
Okay. All right, and you're a US citizen?
Yes, ma'am.
What is the plea agreement for the record?
Yes, Your Honor. The plea agreement is that the defendant will be pleading to count 3, possession of a controlled substance, specifically cocaine, less than 25 grams. And count 4, maintaining a drug house. Upon successful plea and sentencing, counts 1, 2, 5, 6, and 7, as well as the again, yes, I'm sorry, he will be pleading the habitual 4th as well. It is written in counts 3 and count 4.
I see at the top, so.
Yes.
Please, the official.
Yes, he will plead to the 4th. I apologize, I'm
Okay.
doing this for another attorney. There were a sentencing agreement to a minimum sentence would be fixed at 20 months. MDOC max is 15, and to run concurrent with any PV sentence. The defendant also agrees for forfeiture of all seized narcotics and weapons, even in dismissed counts.
Full, fair, accurate, and complete?
It is, Your Honor.
Full, fair, accurate, and complete?
Yes, ma'am.
All right, and counsel, you're waiving reading counts 1, 2, 5, 6, and 7?
I am.
As to the reading of 3, 4, and habitual 4 in its entirety, thank you.
Yes, Your Honor. People of the state of Michigan versus Mohammed Idris Perkins, state of Michigan, county of Hingham, in the name of the people of the state of Michigan. The prosecuting attorney for this county appears before the court and informs the court that on the date and the location described below, the defendant in count 3, controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams, on or about August 21st, 2025, at 2700 Eaton Rapids Road, Lot 200, Lansing, Michigan, 48911, Ingham County, State of Michigan, the defendant did knowingly or intentionally possess less than 25 grams of a mixture containing a controlled substance, cocaine, contrary to statute. This is a felony that is punishable up to a maximum of 4 years. However, with the habitual offender, that would be a 15-year offense. Count 4, controlled substance maintaining a drug house. On or about August 21st, 2025, at 2700 Eaton Rapids Road, Lot 200, Lansing, Michigan, 48911, Ingham County, in the state of Michigan, the defendant did knowingly or intentionally keep or maintain a dwelling that was used for the keeping or selling of controlled substances in violation of Article 7 of the Public Health Code, being MCL 333.7101. And 12, contrary to statute. This is a high court misdemeanor that is typically punishable up to a maximum of 2 years and or $25,000. However, with the habitual fourth offender status, it would be a maximum of 15 years. The habitual offender fourth notice, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, in that on or about December 21st, 2016, he or she was convicted of the offense of controlled substance, possession less than 25 grams, in violation of MCL 333.7403285 in the 30th Circuit Court for Ingham County in the state of Michigan. And on or about June 7th or July 7th, 2021, he or she was convicted of the offense of controlled substance, possession less than 25 grams, in violation of MCL 333.7403285 in the 30th Circuit Court for Ingham County in the state of Michigan. And on or about October 8th, 2024, he or she was convicted of the offense of carrying a concealed weapon in violation of MCL 750.227 in the 30th Circuit Court for Ingham County in the state of Michigan. Therefore, the defendant is subject to penalties provided by MCL 769.12. Those penalties being life if primary offense was a penalty of 5 or more years, or 15 years or less if primary offense has a penalty of under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. Court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition, without taking the time of arrest, and against the peace and dignity of the state of Michigan.
Thank you. Make sure all phones are turned off. Sir, did you understand it was just read?
Yes, Your Honor.
So you understand count 1, weapons, firearms, possession by a prohibited person, normally a 5-year, I'm sorry. I forgot to cross that out. It's count 3. Not count 1. Count 3, possession of a controlled substance known as cocaine, less than 25 grams, normally a 4-year felony. Because of the habitual fourth, there is the enhancement to 15 years. You understand that?
Yes, Your Honor.
And you understand count 4, maintaining a drug house, controlled substances, normally a high court misdemeanor of 2 years, now is a 15-year.
Yes, ma'am.
And let me just ask the status of the 23358 FH file. He's not completed probation, correct?
Not on the 23 case. What was the latest case, the CCW? The CCW. No, he's just on probation on the CCW.
Yeah, he was sentenced October 7th, 2024. You're still on probation for that.
Yes, ma'am.
So I just want to be clear, the intention is that this will be revoked or closed and whatever time is on.
Right, yes.
All right, so I'm going to set this the same time as sentencing.
That's great. Judge.
Okay, great.
And I'll enter my appearance on that. Then.
Okay, I have you.
Do you?
Oh, no, I don't. You know what? I wrote a note on this, that this file should travel with this file that you were on. So
I'll make sure it's done.
Yeah, do an appearance. Okay. So, sir, Looks like you signed the advice of rights form. Did you read it before you signed it?
Yes,
Did
ma'am.
you understand what you read?
Yes, Your Honor.
And if you had any questions about your rights, you're able to talk about those with Mr. Blackman?
Yes.
Do you have any questions about your rights at this court?
No, ma'am.
And sir, you understand you're giving up your automatic right of appeal. If you choose to appeal, you first have to ask permission of the Court of Appeals. If you have a bench trial, a jury trial, you have an automatic right of appeal, but now it becomes their decision if you choose to appeal. Do you understand?
Yes, ma'am.
All right. Sir, as to count 3, possession of a controlled substance known as cocaine, less than 25 grams, how do you plead?
Guilty.
As to count 4, maintaining a drug house, controlled substances, how do you plead?
Guilty.
And sir, you understand that you are giving up your presumption of innocence, your right to a trial, your right to cross-examine witnesses and evidence, your right to choose to bring evidence in your defense and request witnesses that the court would provide, the right to remain silent, not have it used against you. You understand you're giving up all of that.
Yes, Your Honor.
All right. And you chose to plead after you spoke with your attorney,
Yes, ma'am.
and your plea to both counts has been freely made of your own free will,
Yes.
and you've been satisfied with the representation of your attorney.
Yes, ma'am.
And there is this recommendation as to sentencing for 20 months in the Michigan Department of Corrections that will run concurrent with your other file. If I violate that, I would allow you to withdraw the plea, and this matter would again go to the pretrial stage. However, if you violate the law between now and then, I don't have to honor that. I'm not locked into that. I don't have to allow you to withdraw your plea. Do you understand that?
Yes, ma'am.
All right, very good. Sir, did these events occur on or about August 21st, 2025?
Yes.
In the township of Delhi County, Bingham State of Michigan,
Yes, ma'am.
at a specific location known as 2700 Eaton Rapids Road, Lot 200?
Yes, Your Honor.
Did you have in your possession at that location 20 mixture containing less than 25 grams of cocaine?
Yes, ma'am.
And how is it you came in contact with law enforcement? How did they come to find it? Was there a search?
There was a search of the rest.
Search, Your Honor.
And was there a search warrant?
Yes, it was legal.
And so if there's any defect in that warrant, it's being waived.
Right.
All right, I take it from what you said, you looked at that.
Yeah, okay.
And you didn't have any license or special permission or authority to have that cocaine, is that correct?
Yes, ma'am.
And when law enforcement found it, do you know where they found it?
In the bedroom, Your Honor.
It was your bedroom?
Yes,
It was
ma'am.
under your control?
Yes, Your
And
Honor.
you placed it there?
Yes, ma'am.
And did a drug test confirm that it was in
It
fact
did
cocaine?
confirm, it was 3.215 grams of cocaine.
And sir, were you also allowing other people to use drugs in your home?
Yes, Your Honor.
And were you also providing some drugs to them or sharing it with them? I don't know if you, were you sharing drugs with them?
Delivering, you sharing.
Sure, yes, ma'am.
Okay. And you didn't have any license or special permission or authority to do that either, did you?
No, ma'am.
All right, and this was done at your home, that's where you lived?
Yes, Your Honor.
All right, on behalf, oh, no, and then we've got the visual force, so you were convicted on or about December 21st, 2016 of the offense of controlled substance possession less than 25 grams in violation of the statute in 30 Circuit Court for Rankin County, is that correct, sir?
Yes, ma'am.
And then on or about July 7th, 2021, you were convicted of the offense of controlled substance possession less than 25 grams in violation of the statute in 30 Circuit Court. You agree with that as well?
Yes, ma'am.
And then on or about October 8th, 2024, you were convicted of the offense of carrying a concealed weapon in violation of the statute in the 30th Circuit Court. You agree with that as well, sir?
Yes, Your Honor.
So you understand that's where the habitual fourth comes. This is now habitual fourth, which is why you have that enhancement from the 4 years to the 15 years to the 2 years to the 15 years. You understand that?
Yes, ma'am.
All right. On behalf of the people, any additional questions?
People are satisfied, Your Honor.
On behalf of your client, any additional questions?
Likewise, I'm satisfied, Judge.
Our council where promises, threats, and inducements other than those already placed on record.
No, Your Honor.
None, Your Honor.
Scored by the court will.
You have, Your
You
Honor.
have, Your Honor.
Thank you. I find defendant's plea has been freely voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, counts 3 and 4 will enter. Counts 1 and 2, 5, 6, and 7 are hereby dismissed along with the habitual 4th in its entirety. Any outstanding warrants, if any, related to this file are also recalled and dismissed. And all controlled substances, paraphernalia, weapons, ammunition, any contraband is hereby forfeited.
Your Honor,
Yes.
isn't it the habitual offense we're going on?
Oh, I'm sorry. You're right. I dismissed the habitual because I originally wrote that. The habitual offense is not dismissed.
Yes,
Nice
thank you.
catch. Okay. So 3 and 4 goes with the habitual 4th. 3 and 4th will go up with the habitual 4th. It is 1, 2, 5, 6, and 7 that's dismissed. Originally, when I didn't see it on, I had that still stuck in my head. Yeah. All right. And your sentencing date.
June 17th at 11 a.m.
Judge, I'm May and June, most of, I do conflict counsel down in Jackson. I got a ton of jury trials with the court considered the first part of July for sentencing.
Well, there you have it. I'm generally like in the sun and however, I do have,
June 24th is the next day I have.
okay,
the
June
full-
24th.
May and June, I'm down in,
Oh, yeah, okay, so, well, let me ask you this, counsel, can we do it on Zoom?
we could judge, but you know, he's got time in, I mean, he's gonna be sitting there and it's a 26,
Yeah,
so it really doesn't.
well, so, and this is not dead time, so he's getting.
No, it's not dead time
All right,
at all.
let's just do it in, August.
I don't
We're not in any hurry to get to prison, are you? All right, let's do August.
I don't know. On the call.
Okay. I guess we'll be hosting you for a while. All right, I need a date in August for a sentencing. Let's do the 19th. What time? 9:30 is fine. Thanks. All right, August 19th at 9:30.
Thank you, Judge.
So you're gonna have to cooperate with probation, but they're going to come and see you. And they're gonna do a detailed pre-sentence investigation report. They'll probably just update the one that you have in your other file. But what I'm going to do is set both of these files for that day. And then I have to see what you completed on the 23-358 H file. If you've done enough, I'll simply give you credit for that. Otherwise, I'll send it to you on both. Does that make sense to you?
Yes, ma'am.
Okay. So, and Mr. Blackman, you're gonna file an appearance.
I will do that, Judge.
And we'll take a look at that. Maybe you want to talk to the agent. We'll.
I think we are, Randy Bierman, who was on this, is already in counsel.
Okay, thank you. And that's all for the record.
Thank you,
If need
Judge.
Something over in the jail or not helping you out, let your attorney or me know, okay?
All right, thank you.
Okay, friends, let's head. Yeah, I think we've got time to do it. Let's head to the parole board one more time, and then after that, we'll go back to the Wexford County prelim from yesterday.
Is April the 9th of 2026. We're in Baton Rouge. We've been conducting hearings and we've introduced ourselves already. And you can see from our name tags who we are. And we're there at Jefferson Parish Correctional to talk to Mr. Travis Duckworth. First, I'd like to hear the Jefferson Parish staff. Would you introduce yourself that's there?
Yes, sir. Deputy Landry with the Jefferson Parish Sheriff's Office.
Okay, thank you, sir, for hosting us today. We appreciate it. Mr. Duckworth, it's your turn now. Is that you, Mr. Duckworth, that I'm looking at?
Yes, sir.
Okay, and what's your DLC number?
425654.
Okay, your case has been assigned to Mr. Freeman. He'll go over your form that you signed and everything else, conduct the initial interview, and then we'll ask questions after we hear from those in favor and we'll make our determination if you're revoked. Mr. Freeman?
Okay, Mr. Duckworth, you're charged with, do you have your parole questionnaire with you?
Yes, sir.
Okay, do you realize you're not eligible for appointed counsel? If you wish to have counsel, you'd have to hire one.
Yes, sir.
Want to proceed today without without counsel?
Yes, sir.
Okay. All right, Mr. Duckworth. It is alleged you violated condition number 4. I will not engage in criminal activity, nor will I associate with people who are known to be involved in criminal activity. And you will avoid bars and casinos and refrain from illegal use of drugs or alcohol. On 12/11/25, Travis Duckworth was arrested by the Louisiana Probation and Parole and booked into Jefferson Parish Correctional on a warrant from Jefferson Parish Sheriff's Office for the charge of domestic abuse battery, second conviction. How do you plead to that charge?
Not guilty.
Okay, tell me what went on.
Me and my wife had an argument, and we was at a hotel, and they had called the police on her. I ain't physically touch her though.
Did you threaten to kill her?
No, sir. No, I said, yeah, I did. Yes, sir.
Okay. Okay, I appreciate you being honest about that. Have y'all ever been to any kind of counseling or treatment together, you and your wife? This has happened in the past, has it?
Yes, sir. Yes, sir. We haven't been in counseling. We're trying to get into it.
Okay. So how did she get the blood around her ears?
I think that come from an earring.
Right. And did that come from you pushing her in the face?
No, sir.
Okay. All right. And like I said, so the battery before it was on the same victim?
Yes, sir. I actually did that, and I pleaded guilty to that.
Okay. Anybody have any other questions with regards to condition number 4?
Well, do you know that the interview with your wife is on police body cam video and she tells a different story?
I heard the what she said. I was in dust.
So she was probably lying?
Yeah, she could tell you that I didn't touch her. She was supposed to be on the video camera too.
She's here. We're gonna allow her to speak at the proper time.
That's only.
Okay. And then you had condition number 10 that you were behind on your fees. How you plead to that charge?
I plead guilty to that.
Okay. Okay, let's go and hear from, well, first let's hear from Eva Adeki, your mother.
I just wish it's.
Hi, Ms. Adeki.
Hello? Hello?
We can hear you. What you want to tell us about your son?
Well, I think my son was doing very well. He was in school, he was working, he was doing very well. Him and his wife's situation is up and down. They're together, they're apart. It has been a constant up and down with them. I don't think that the situation that happened was 100% his fault. I think it was both of them fault. Because as toxic as their relationship is, they don't seem to be able to stay away from each other.
Thank you, ma'am. Appreciate it. All right, let's hear from Miss Terrion Duckworth.
Hello.
What happened?
What happened?
Yeah.
So basically, we were at the hotel room. We got into a heated argument. I think the whole situation was just a misunderstanding. The part when I did write the letter, I was in a hurry to write the letter, but the part that I did forget to mention, I didn't know if I could write a second letter. But then night we were at the hotel, I was very intoxicated. What I will say is that my husband did not physically touch me. Now I did have blood behind my ear. I'm thinking it's because of my earring, but he did not physically assault me at all. It was just an argument that just got out of hand.
So
And
they
that's
changed the story from what you told the cops on
because
body.
I was intoxicated, so I don't even remember everything that I told the cops at the time. I was intoxicated, I was emotional, so I don't even remember. Like the situation happened so long ago, even the next day I didn't remember most of what happened because I was very intoxicated.
So what y'all at the hotel for?
Because on my days off, we just like to have our time apart and, away from, my kids, we just like to spend time just one-on-one with each other on my days off from work. Because I work a lot, I work hard, so we just like having that one-on-one time.
Okay. Any of my colleagues have a question for Ms. Duckworth?
You are also a victim in a prior domestic abuse charge too. Tell us about that one.
Well, that situation, it was another argument. I had told my husband, well, he wasn't my husband at the time, but we got into an argument. I told him to leave the house. I started throwing his clothes and stuff, and then it just got out of hand. I did get in his face, and then the situation just took a turn from there.
Sounds like you're telling us in both of these incidents, you provoked the arguments, you caused the trouble, and then now you're trying to take responsibility for it because you're drunk or
Yes.
because of that, correct?
Yes.
I'm done.
Did you change your story the first time also?
I'm not.
Yes, you are.
I don't know if I changed my story. This situation was years ago, so I don't remember the situation.
So you don't know if you recanted. Do you know what the word recant means?
I do know what it means.
Okay, did you recant the first time?
The first time, no, I don't believe I did.
Did you testify against him in court?
No, I did not.
Did they ask you to testify against him in court?
I don't believe so.
You don't believe so?
You talking about from years ago?
When he went to jail?
When he went where?
In 2024.
No, I don't believe anybody asked me to testify.
Okay, was that the time he went to jail? Was the time y'all's last domestic abuse charge that he had?
I'm confused if you're talking about from 23 or from.
Let me talk to him again.
I'm confused.
Yeah, I pleaded guilty.
Mr. Duckworth.
Yes, sir.
You pled guilty the last time, right?
Yes, sir.
And that's for beating her up, right?
Yes, sir.
Okay. Hey, that's all the questions I got.
No, I had took a plea deal. It didn't go to trial. So she wasn't asked to testify.
Okay.
Now ready to vote?
I'm ready.
I got one more question for her.
Okay.
Are you telling us today that you do not fear him? You do not think anything would happen to you if we let him go or anything like that?
I do not fear that at all. I want my husband to be home. He really is a good man. We have our arguments. We're trying to get in counseling, so work on communicating better, but I'm not afraid of him. I don't think he's going to harm me. I don't fear him. I want him to be reinstated. Like, I don't think that any other situations are going to happen because we're determined to, be better and motivate each other and just, work on our marriage. I'm not afraid of him at all. So I would love for him to be reinstated because he really is a good man. He has a good heart. I'm not afraid of him.
And if he were to be released, you would agree to hold harmless the parole board, the state of Louisiana, probation and parole, and anybody else involved with this
Yes.
case? Harmless, should he come and kill you tonight?
He's not going to kill me.
Okay, just want to make sure you agree to all this. Not saying you're gonna get out, he's gonna get out. I'm just covering the bases.
Okay.
All right.
Any vote?
Great.
Okay, Duckworth, I got to be totally honest with you, I don't believe y'all. I think the battery did occur and it has occurred before, and on the side of public safety, my vote today is to revoke. You violated condition number 4 and number 10.
Mr. Duckworth, I've got to concur with that. I think there's too much smoke here, and especially you just got out of jail, just got paroled for similar behavior as what you're accused of today. I feel like that because of violation of conditions 4 and 10, that you're violated those conditions. My vote is to revoke.
I'm gonna concur with the panel, same reasons. Revoke.
As of 9:27 this morning, your parole has been revoked.
Revoked, my friends, again, as before, to the surprise of no one. Okie dokie, let's do this real quick, because while that was going on, I was working. In the chat, I just dropped a link. I just posted an article on Substack. Feel free to check that out. Again, if you are not subscribed to me over on Substack, please do so. It comes at the low cost of $0 a month. I am not charging over on that platform, at least not at this time. Maybe someday in the future we'll have premium posting, but for now, everything is free. And I give you in this post my thoughts on that Louisiana parole board hearing that we saw the other day, where you had one family member who was ready to forgive the woman who murdered the victim, and you had another one that brought a 121-point list to the board about why he hated that woman and why the board should hate her too. So give that a look. Okie dokie, let's go back to what we were watching yesterday. So this is in the Wayback Machine from yesterday afternoon after we had ended the show. This is a continuation of the preliminary exam for the lady who ran the adult foster care facility. Just to remind you, she's charged with involuntary manslaughter. This is a preliminary exam to determine whether or not she should be bound over to circuit court. And this goes on for about 50 or so minutes, so it should take up the 4th hour. But let's pick it up. Just a warning, there's a couple of spots in here where some weird stuff happens. Just stick with it. Some of it's kind of funny.
All right, so we are back on the record after an adjournment earlier this afternoon on the preliminary examination. I believe the people still had a few witnesses to call, so I'll turn it back over to the people.
Thank you, Your Honor. The people would next call Dr. Paul Wagner.
All right, doctor, if you make your way up next to me here. Before you're seated, if you raise your right hand, you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
I do.
You may have a seat. Whenever you're ready.
Good afternoon, Doctor. Thank you very much for your patience this afternoon, waiting to testify. Will you please state and spell your name for the record, please?
It's Dr. Paul Wagner, Wagner.
And Dr. Wagner, can you please give the court a brief summary of your education, training, and experience in osteopathic medicine?
I graduated from Hainer University with a doctorate, and then I went to University Hospitals in Cleveland for my residency in family practice. It included inpatient and outpatient care. And then after that, I became an emergency room physician for 5 years. And then after that, I settled in Hart on a rural health grant, and I've been there since for approximately 35.
And what have you been doing for the last 30 to 35 years?
Practicing medicine in Hart, Michigan. I am the medical examiner for the last 31 years. I'm the jail physician, and I also worked the emergency there a little bit, and I did a lot of inpatient therapy, but now we transfer all that to Muskegon.
And are you the medical examiner for Wexford County?
I am.
And you also do a outpatient clinical practice?
A lot, yes.
Okay. Do you treat, in that capacity, do you treat patients with chronic conditions such as diabetes?
Yes, because I've been there for 31 years, all my patients that were 50 are 81 now, so I treat a lot of that.
As the Wexford County Medical Examiner in November of 2022, did you have occasion to become involved with an investigation or an inquiry? I'm not certain of the correct term, into the death of a lady named Kelly Harris.
Yes, I have the subpoena here, so okay if I bring it out?
Sure.
Yes, I am.
And please, if you would, describe the process generally when you get a referral as a medical examiner to what's the proper terminology? Is it an investigation or an inquiry?
Yes.
Okay. What is the process that you go through when you're asked to look into a death?
In this case, we were notified that there was a death that had occurred, and I'm sure you already talked to Dave Harrison that was in here earlier. He got called on scene and he investigated. He's a certified medical examiner investigator. All our investigators have to get nationally certified because we want to hit the best quality measures. So David went on the scene, he investigated it. Then he reported to our head investigator, David Turner. And then David would call me and then we discussed the case about what needs to be done. Is it a natural? Do we need an autopsy? Do we need further investigation? And then we conclude the cause and manner, and then that's how it usually goes.
So what specifically happened in this case? How did the investigation play out?
Okay, so David was called to the scene. He did a full evaluation, acquired data, and then he called David, and then they discussed it. Then David called me, and then we discussed it, and we were determined that because of no evidence of foul play, no evidence of this, that it was a complication of a chronic disease called diabetic ketoacidosis.
Hold on. Your objection?
We are getting into diagnoses and expert level testimony.
He has the process. He mentioned the diabetes.
There's been no motion to have the court recognize the doctor as an expert.
Well, I guess I would make that motion, Judge. It's clear that Dr. Wagner has extensive experience in this field. There's nothing particularly unique about this case that I'm asking for an expert to render opinion about something he wasn't involved in. This case is that the person, Dr. Wagner, was personally involved in this situation. So he could talk about the decisions that he made and the basis for those decisions. But I would also, if necessary, I will ask that he be qualified as an expert as a medical examiner.
Is there any objection to qualifying him as an expert?
Just a moment to voir dire, if I could.
Sure.
Good afternoon, doctor.
Hi.
As a medical examiner, have you had occasion to perform autopsies?
In residency and training, and I would observe them.
How many autopsies have you participated in?
For observation purposes, when I first moved up here, Dr. Steve Cole, Grand Rapids forensic pathologist, he's kind of my mentor. When I moved up here from University Hospitals, the local sheriff walked into my room and said, okay, you're the medical examiner. I said, nope, I have no idea what I'm doing. So then I called Steve Cole and he sent me through the educational process, you know, what to do logistically, processes, things like that.
Have you participated in autopsies of people that died from diabetic ketoacidosis?
I'd have to check my records. But I treated diabetic ketoacidosis numerous times in the intensive care unit, as well as the emergency room. So I'm well versed in the pathology and the diagnosis of it. And to this day, I still manage insulin pumps and numerous, I'm a clinical professor at Michigan State, and they did a database on me, and I had like 453 registered patients that had diabetes as their diagnosis. So I'm well versed with it. And matter of fact, in my subset, when I had to take my recertification boards, I made sure that one of my subsets was the diabetes subset to meet that criteria.
How many investigations into suspected death from diabetic ketoacidosis have you been involved in?
Quite few. It's very common. Diabetes is a very common diagnosis. So the end result, you get people who have chronic diabetes that have end-stage organ damage, and diabetes is usually the impetus behind it. Quite often.
Can you put a number on quite often or quite a few?
We do average 3 to 5 cases a day, year round. Diabetes is probably 10 to 20% end-stage diabetics because you got people on dialysis, you have people on congestive heart failure, you have people who have peripheral vascular disease, and these are all end results of diabetes. Diabetes is the thing that transcends everything. It causes your kidneys to fail, your eyes to fail. That's why people go blind. That's why we chop off their legs. Is because diabetes eats these people alive when not controlled. So if you threw the diabetic moniker in it, I'd say 10, 20% of my cases is diabetes related. Over the course of 31 years, I've probably done 30,000 cases. So I'd probably say 3,000.
3,000 deaths.
You're asking me to guesstimate.
Okay, well, I mean, you're the expert.
Well, it's what I've done for 31 years.
And do you happen to have a curriculum vitae with you?
I'm not with me, but I can sure give you.
Okay, if you can provide it to the prosecutor.
Absolutely.
I have no objection.
All right, the witness is so recognized. You may continue.
Thank you, Your Honor. So counsel raised the question of autopsies. Was an autopsy done on Ms. Harris?
No.
And why not?
It's not clinically indicated. This patient, unfortunately, she was in a poor state of health. She was frail. And a lot of her end organ problems, her kidney, you notice in her hospital report, they mentioned chronic kidney disease. That was an end result of diabetes. When she was admitted to the hospital, it was because she had what's called a syncopal episode. That's where she just fainted. And at that time was determined she was frail, failure to thrive, she's not eating right, she's active inactivity. She had numerous diagnoses. A lot of them were diabetes related. And over the course of 3 weeks with 24-hour care, 7 days a week for 3 weeks by very fine doctors and nurses, they did numerous tests. They checked her heart, they checked her brain, they checked her spinal column. They did numerous testing, numerous lab works. So an autopsy wouldn't provide any more clinical data. She had an extensive medical workup in the hospital. And the fact that her symptomatology, the fact that her sugars were at high, usually most machines high is like over 500. At 500, if you're not getting IV fluids, and it's called an insulin drip, and as well as potassium supplementation, if you're not getting all these factors at once, it's a cascade. You go into what's called sepsis. That's where all your organs are haywire and out of control. So the fact that she had diabetes and her A1C was 10.1, so that means she was a bad diabetic for over a 6-month period. Her A1C, usually when you have a quality controlled diabetic, you want that below 7. Under 7, statistically shown that you decrease the ability to end up on dialysis, ability to prevent blindness, ability to prevent amputations. She was over 10 for at least 6 months. So the fact of the matter is she's had to be 3 weeks in the hospital and she had a numerous medical investigative workup. it would not have provided any of the clinical data because symptomatology, she had nausea, vomiting. She was a sugar of over 500. That is all indicative of DKA, diabetic ketoacidosis.
So it sounds like you reviewed her medical records from her hospital admission immediately before she went into Pleasant Lake.
No, I did not investigate the medical records until after she had passed away. Because on the morning of the thing of our phone call to David's, they said that she just got out of a month in hospital. So we drew a toxicology and we pended the death certificate because we wanted to get more clinical data. Usually we call the family physician because usually we like to get their input, but we never were able to contact the family physician. The physician at the home, I guess, filled out a history and physical 5 days prior. And what was kind of weird because usually to this day, I still treat sliding scale and slips. I do it at the jail, I do it in the hospital, I do it in the office. And there's always a stopgap measure. So like when I have a patient in the jail, if their sugar 0 to 150, no insulin. 150 to 300, give them 4 units. If their sugar's over 300, they gotta call me. And then when they call me, they'll say, okay, Paul, it's 310. I'll say, okay, give them 5 units. If they call me and say, Paul, it's 470, I'm saying, get them to the hospital because they gotta get the IVs going. They gotta get the fluids going because you're hitting that critical mass. So
are you, again, can you give me a succinct, I appreciate all the information, thank you. Can you give the court a succinct answer as to why no autopsy was done in terms of?
It wasn't clinically indicated. I thought I reiterated that.
I understand.
It would not have brought any more evidence to the table.
Okay.
It would have been superfluous.
Okay, thank you. So
I hate to interrupt, but we've got an issue going here that we need to address. Is that?
What's gone?
Well, sounds like smells like we have a very hot printer over here.
No.
Who says nothing happens in this courtroom? So, just minor details, just a few scorch marks on a pad. So you may continue.
Thank you, Judge. Doctor, so based on the information that you've just discussed and the information that you had regarding Ms. Harris, did you make a determination regarding the cause of her death?
Yeah.
And what was that?
Diabetic ketoacidosis due to having a history of control.
May I approach the witness, Your Honor?
May.
Here's the court's copy of People's Exhibit 1. I'm handing you what's been marked as People's Exhibit 1, Dr. Wagner. Can you please identify that exhibit?
Yep, that's it.
I'm sorry, what is the exhibit?
The death certificate
for
For Kelly Harris.
And that death certificate contains the information that you just.
Yes,
related
that was my
regarding that.
conclusion based on the totality of all the information that I received. Correct.
Thank you, Doctor. Move to admit People's Exhibit 1.
Any objection?
Objection.
One is received.
Doctor, you mentioned, I think you mentioned long-acting insulin, I'm sorry, or either short-acting or long-acting, one of the two. Can you explain the difference between short and long-acting insulin?
Yeah. Long-acting is like a slow burn. You take a shot and metabolize the glucose at a slow rate over like a 24-hour period. With a fast-acting, you squirt in the system, it works right now, like within an hour, you get the maximum dose. So you use a combination of the two. Usually you give them a slow burn throughout the day, and then when people are gonna eat, their sugars will spike. And then you give the fast-acting to help facilitate the sugar going into the cell at a rapid rate.
So it sounds like the long-acting is sort of a baseline.
Yes.
And then the short-acting is like
the thrust
acute situation where you need to bring it
get
down quickly.
now. Correct.
What type of insulin is Lantus insulin?
Long-acting.
Okay. And what type of insulin is Aspart insulin?
That's short-acting.
Okay. So if, let's say Miss Harris did not receive any insulin while she was at Pleasantly Live from November 1 through November 4, would that be consistent with the outcome that she experienced?
Yes, but the thing that when I reviewed the records, there was evidence that she had it or not had it. So that was a tough variable. The one thing I was basing my conclusion on was these persistently high sugars. The fact that she was a long-acting, she had diabetes for years and it was poorly controlled. And the fact she had these residual high levels led me to believe that that was totally in DKA. And the fact that she demonstrated the symptoms, the nausea, the vomiting, and working in the emergency room for all those years, she had the classic presentation of someone in DKA. So yes, I mean, if you're not getting the medication, but the fact of the matter is, I didn't know if she was getting it or not.
Well, I'm asking you to assume that she wasn't getting any insulin for 4 days. Is that consistent with dying from diabetic ketoacidosis?
It would be a contributor, absolutely.
Okay.
The fact, I mean, how is her hydrational status? How is her immunology status? How is her hematology? You got to look at the big picture. I make sure I look at all the different variables.
Understood. Putting it, sort of flipping the coin, if she had received her insulin as prescribed, would she have had a better chance of surviving that time period?
If she had sugars over 500, she needed to go into the hospital with medicine or not. See, that's why you have that sliding scale. It's kind of a fail-safe barrier. At 350, you call the doctor. At 4 over, whatever her sliding scale said, you get them out of there. So so was that implemented? Was that part of the process? So I got to consider that variable if she had it or not. So it's great, I guess. Okay. To give a definitive answer without knowing the data, it's hard to give an answer. I do know she died of DKA related to diabetes. Was not her getting medicine or getting medicine the total cause of it?
I'm not saying was it the only cause, but
Right.
what I'm saying is, if she had received insulin as prescribed, is it more likely than not that her blood pressure, that her blood sugar would have been lower than it was?
Well, in the hospital, the nice thing about the hospital, it's 24-hour care, 7 days a week. You always have nurses checking the sugars before they're getting the insulin, the regimen. If she was adhering to that regimen, absolutely. Because they were able to get it clinically stable in the hospital, where then she's out of the hospital.
This is one of those incidences / hiccups I described before we started. The audio will come back here in just a moment.
Gentleman before, but
Sorry.
but as the sign off medical examiner, yes.
It wasn't Rebecca Youngman?
Was that the hospital doctor?
I mean, do you know who that person is?
No.
So you didn't have a conversation with her about you handling this case on this particular day?
That might have been one of our students. Because we have students that follow, that we're training. It might have been a student.
But you know the name at least. Is it recognizable to you?
I want to see the name because I don't want to have brain fog in a situation. I'd like to see the clinical data.
No, Rebecca Youngman. Do you know that name or not?
It doesn't ring a bell, but
Okay.
I could have somewhere in my past.
Okay, I'll move on. So no autopsy of Miss Harris because not clinically indicated was your testimony?
Correct, because of the extensive workup of 30 weeks of under physician and nursing care. The only thing they concluded was the fact that they're diabetes. They checked her heart, they checked her brain, they checked her back, they checked all the other items, and her blood work showed their liver enzymes were good. The only thing was the kidney disease secondary to diabetes. She was not anemic, so she had no evidence of bone marrow cancer. She was adequately anticoagulated, so that would eliminate any evidence of a blood clot or pulmonary embolism. Her chest X-ray showed her lungs were clear.
She had coronary artery disease.
Probably secondary to the diabetes.
Is that a yes?
Yes.
In the native valve?
And she did have an echocardiogram in the hospital. And she also had cardiac enzymes, which would show no indication of cardiac damage.
So carotid stenosis?
She had a carotid endarterectomy. She actually had that removed at one point.
Hyperlipidemia?
That's high cholesterol.
Okay. Hypertension, high blood pressure. That was significant, right?
Mm-hmm. But it was controlled in the hospital.
Obesity, morbidly obese. These are yeses?
Those are yeses, I'm sorry.
Okay. 5'6", 280 pounds. Yes?
Yes, I'm sorry.
And
end of the day. I'm tired.
So a BMI of 45.2.
That's morbid obesity.
That was her.
Yes.
Peripheral artery disease?
Yes.
That's in the limbs or peripheral?
Anything outside of the main arteries. So like your legs, your arms, stuff like that.
Supraventricular tachycardia.
That's a rapid heart rate, usually caused by people that are hyperthyroid or hypothyroid. She had part of her pituitary removed as a benign tumor. And as a result, she was on a thyroid medication as well as the ADH medication called Florinef. It helps regulate your cortisol levels.
All of those diagnoses you agree she had?
Absolutely. And the majority of them were contributed by diabetes.
I don't disagree with that.
Okay.
All of those diagnoses that I just mentioned are contributing factors to cardiac events.
The main one being diabetes.
Heart attack?
The main one being diabetes. I've had a lot of diabetics that have heart caths.
Right.
And especially the peripheral artery disease. That's a common denominator amongst a ton of diabetics.
So is it your testimony that if somebody died of a myocardial infarction, is that the technical name for a heart attack?
Yes.
If that was your finding as the cause of death, if that person had diabetes, you would list?
I would have put acute myocardial infarction with a contributing factor diabetes mellitus. And I would have called the cardiologist and he would have said, well, this person had diabetes for years. It helped facilitate the process.
So what were your differential diagnoses when you looked at all of the evidence?
Basically everyone you said. You gotta go through the whole list. I
So
got
what test did you do to rule out a heart attack?
3 weeks of clinical data from the hospital.
What tests?
The echocardiogram, the cardiac enzymes, they're on the hospital record.
Did you
As
do
well
a,
as the CT that had to rule out a stroke and possibly an aneurysm? And you're worried about the carotid stenosis. You can look at the cervical arteries on the CAT scan too.
so you looked at past records, isn't it possible?
I looked at the emergency room records, her presentation to the hospital, where she had her first initial syncopal episode. And in the emergency room at that time, they found that she had a little bit of chronic kidney disease. They didn't know if it was acute or chronic. They also felt that she was dehydrated. And they also found that her diabetes was uncontrolled. Due to these variables, they wanted to work her up because with the syncopal episode, you got to worry about heart disease, you got to worry about a stroke, you got to worry about, blah, blah, blah. So they admitted her to the hospital.
Because those are real concerns, right?
Exactly. And they addressed all those concerns with diagnostic testing of the CT of the head, of an echocardiogram. They checked her heart. They checked her cardiac enzymes. They checked her kidney functions. They checked her liver functions. They checked to see if she had a GI bleed. That's very common.
So is it your testimony that somebody that gets checked a month before can't have a heart attack or stroke a month later?
I'm giving you my medical opinion based on 31 years of
So that's a
experience.
yes?
It's a variable you got to consider, but the fact of the matter, she did not complain of chest pain. She did not complain of shortness of breath. She did not complain of any cardiac symptoms. She did not complain. The only thing she cleaned up was consistent with diabetic ketoacidosis based on 31 years of treating the condition and continue to treat the condition.
So none of those symptoms that she expressed could be symptoms of an impending heart attack or stroke.
As a physician, it's my opinion that she got DKA.
So you didn't answer
my
Doc, you didn't answer my
that
question.
they checked her heart, recently with an echocardiogram that showed good ventricular function.
Did you
So
do
yes, it's possible. Everything's possible. You got to put everything on the differential, but based on the evidence and the data provided to me, I'm sticking by DKA secondary to diabetes.
Good for you, doctor.
Thank you.
How hard would it have been to do a troponin split test?
She had one done in the hospital.
She did? Oh, and you have that, do you have those records?
I might. Discharge sign. She had over 900 pages of hospital records.
Take your time.
So, and I just got the discharge summary and the ER report and the history and physical. So probably the ER report. There you go, cardiac monitors, latest results, CK, troponin, HS, high sensitivity on 10/13/22.
10/13/22. And troponin is a substance that will show damage to the heart.
Correct, as well as the CK. The CK,
So-
the CK is also different.
Oh, hold on. I only need one of you to speak to a time, so go ahead and finish your answer,
Right.
and then you can follow up with the
Right,
question.
he's trying to lead me down a path, but a CK can also indicate liver, brain, soft tissue. So if you have an elevated CK, then you know that there is active inflammation in the body, which can help rule out other disease processes. Then you get the troponin to actualize it into cardiac related or not.
So the troponin, until you have a cardiac event, that's a byproduct of the damage to the heart tissue.
Correct.
So if you have a test on October 13th, but your heart attack occurred on November 5th, you're not going to have troponin because that event didn't happen yet.
Okay, she did not exhibit any cardiac symptoms. I'm not changing my opinion. She died of DKA secondary to diabetes.
What test did you do to rule out a stroke?
She had a CT in the head and
At the hospital.
when she had her syncopal episodes, And they checked the CT and she had no evidence of it, and she was not demonstrating syncope in the home. She was developing nausea and vomiting, which are DKA symptoms. She did not have signs of syncope. She did not have signs of chest pain. She did not exhibit any of the signs in the physical exam.
Nausea,
She
vomiting, aren't
just
signs of-
heart failure. She didn't exhibit any edema. Her physical exam was completely normal.
She had
In my
severe-
opinion, DKA.
I, for the record, duly noted.
Okay.
She was severely dehydrated
From the, yeah,
prior to leaving the hospital. She had no fluid output for at least the 48 hours before release. At
that
stage
would
3.
be lead to what's called lactic acidosis, dehydration, lactic acidosis, as well as having kidney renal functions.
Dehydration can be a contributing factor to a heart attack or stroke, correct?
You got a DKA secondary.
Doctor, please answer the question as directed by counsel.
Okay, what was the question?
Dehydration can be a contributing factor to heart attack and stroke, correct?
Dehydration can be contributed to any disease.
That's a yes then?
Yes.
Nausea and vomiting can precede a heart attack, can't it?
It can. It's possible, it's theoretical.
What about the lack of any evidence of coma, stupor, or somnolence? As a symptom of a fatal case of diabetic ketoacidosis.
A sugar of 500.
You didn't answer you're not answering the question. Is it not true?
Everybody presents differently. It's not a perfect world with symptoms.
How many?
If you have someone that has a sugar of 500, common sense would tell you that the vomiting a week, that is really the DKA. The fact that they didn't exhibit other symptoms, everybody's different.
You're not answering the question. Isn't it true in every recognized medical literature that a diabetic coma or stupor precedes a fatal incident of diabetic ketoacidosis?
Absolutely not. I've treated it. I've had people that they've hit stupor. Usually their sugar's around 700. Everybody's different. It's not an exact, if you're stupor, that precedes it.
So it's your testimony
I've
that
seen people die of DKA. I've seen people on ventilators. I've treated it. I've done it. It's not a perfect world. It's not raveled out like that.
what, in all of your years of experience with diabetics, what percentage of the fatal cases you dealt with did not involve a coma preceding the fatality, or stupor, or somnolence?
I have no idea. I'd have to look back at 31 years of data.
Might want to do that.
Okay. Yeah.
If there's evidence that she was awake and talking to her roommate at 4:30 in the morning, and she was found about 4 hours later, and she was cold and rigor mortis had begun to set in.
Okay.
When does rigor mortis begin in a human body?
It depends on the temperature, the diabetic state. You know, she was
Room temperature.
Room temperature, 2 to 6 hours, peak at 12 hours.
2 to 6.
Yeah.
So if she were talking and conscious, not in a coma or a stupor, at 4:30, and she had signs of rigor mortis 4 hours later, where would you put the likely, in your expert medical opinion, where would you put the likely time of death?
2 to 6 hours. Likely death. What time was she talking to somebody?
4:30 in the morning.
And what time, 9 o'clock was the investigation?
Calls went out about 8:30, 8:45.
Yeah. That could happen.
And since she was cold, and rigor had begun, would you say that it was more likely that she died before 6:30 or after?
I would have to say before, because that's only 2 hours.
Okay. And if there's evidence that, well, isn't it true that a very common symptom, again, take a look at the literature about,
I've lived the literature.
Would you call it a violent thrashing type of death due to diabetic ketoacidosis?
No, she was weak. She was vomiting.
So if she were thrashing around to the point where she had spun around on her bed and her clothes were disheveled,
you would have probably, the physical exam would have shown that. Her physical
Well,
exam,
that's where her
other than
body-
the wound on her left ankle, her physical exam was pretty benign. And the fact that she had the wound on the left ankle was attributed to the diabetes, because diabetics have a horrible time healing.
someone's much more likely to thrash around reacting to the trauma from a heart attack than with diabetic ketoacidosis. Isn't that correct?
Usually my diabetic, they're usually in a stupor.
Thank you.
Yeah, end stage.
A stupor.
And when they're about to die.
And that usually lasts, according to recognized medical literature, 12 to 24 hours, right?
No, and she was probably in it for 2 to 3 days, because she died on the 5th. So yeah, that's about right. She probably went into total decay probably around the 3rd or the 4th.
Her uncontrolled diabetes, that condition, that existed a heck of a lot longer than the 4 days she spent at Pleasant Lake, correct?
Yes, she had it for a long time.
And self-medicating or self-monitoring patients. They have you're familiar with the Libre 2?
Oh God, I have 30 patients on it.
Okay. That's a method of self-monitoring, correct?
It's very efficient, yes.
So somebody that is non-compliant with the medication or the monitoring, it's up to them to check it themselves and to notify professionals that they need medication. If they're self-checking their blood sugar, which she clearly was.
Right, and it was clearly high. And
Yeah,
again, the protocols I am used to is the fact that you get a phone call at a certain level, and then you either give insulin or you ship them to the ER.
So at the hospital, she wouldn't have been, the nursing staff, the medical professionals wouldn't have relied on the Libre 2.
No, usually, again, there's over 1,000 patients or 1,000 pages of that document. But
so what were her?
Usually the protocol is before you eat, you check your sugar, and then you look at the scale, and let's say your sugar's 200, and it says, okay, give 4 units. And then the next meal, you check the sugar and it tells you how much insulin to give. But if it's abruptly high, based on the level, you call the doctor and they say, well, you could probably give a little more, or no, get them out of there.
So what were her on October 31st, the day before her discharge? What were her glucose readings?
I'd have to look up. I'm not aware off the top of my head. I was more worried about diagnoses and policies. Discharge documents. Okay. Sometimes they don't have it in here. Oh, wait, here you go. The latest results. No, that was while she was in the hospital. She's 117 at that one.
On what date?
That was the day after admission. I do not have.
Wouldn't that have been an important thing for you to consider?
What her sugar was at the time of discharge?
Yeah.
I was more worried about the A1C because the sugar is a frame, the sugar is a frame of the movie. Okay, the A1C is the whole movie. So you assess.
This was a 10.1 at the time she was in the hospital.
Correct.
And that you wouldn't consider that controlled.
Correct.
That's actually really dangerous.
Correct.
So then is it logical that it's your opinion that she shouldn't have been discharged from the hospital?
I didn't make that decision.
What is your opinion? If you were the doctor that was making the decision, you wouldn't have discharged her, would you?
I'm
Not urinating for at least 2 days?
My job is to say how she died. She died.
Doctor, I am asking you a very simple question.
All right,
If it was
you're
your
asking me to
decision.
speculate.
Okay,
You're
stop.
asking me to-
No, stop, doctor. Let him ask the question, then you can answer it.
In your expert medical opinion, if this was your patient, would you have allowed her to be discharged?
Okay.
With
I have not reviewed all of the 1,000 pages record. So until I do that, I will not make that determination until I have all the data. I will be speculative, and I'm not going to do that.
So it's your sworn testimony that you went through the thousands of pages?
I have not.
No, prior to your very heartfelt diagnosis and of cause and manner of death.
I went through the discharge summary, the ER report.
How much time did you spend going through the report that day?
Half an hour.
1,000?
No, not 1,000. I told you, these are the documents I went through. I got the emergency room report. I got the discharge summary and the H&P. I said that multiple times. It's whenever I have a patient.
You spent a half hour and you determined the cause and manner of death.
Mhm.
That's a yes?
Yes, I'm sorry.
Her first glucose reading from her Freestyle Libre 2 at 7:42 on her admit to Pleasant Lake. So she was admitted in the early afternoon. Just a few hours later, she's at 3:02. That's bad, right?
It's getting there, yes.
Okay.
Did she get any insulin at that time?
Did she get any insulin at?
One was 302, because usually you look at the sliding scale and then you administer it.
Is it safe to assume she was getting insulin at the hospital?
Absolutely.
Right. What do you think her numbers were at the hospital?
I have no idea, because I have to look at
That's
some
a good-
of the other pages.
I have no idea. That's good. 7:58, it's 280. 11:15, it's 223. 12:55 the next morning, 11:02, it is 188. At 4:03, it's 183. Those are elevated, but those aren't life-threatening.
Correct.
And you don't know what the cutoff is for the freestyle for a reading of high, do you?
I do not.
You consider that an important factor when you made such a hasty decision about the cause and manner of death?
Object to the characterization.
I based it on.
Hold on, there's an objection. Response,
I'll rephrase it.
please.
You relied on high readings for your diagnosis. The read, and when I say high readings, I don't mean a number, I mean the word high. And you just testified that you don't know what that number that word signifies on this device. Yes or no?
On the Libre, I don't, but on the glucometer, I do.
So the device that she had that gave us these readings, your testimony is you don't know what high signifies.
On that,
Yeah.
on that
Yes.
machine, the answer I would say, I don't know. Absolutely.
Is it your sworn testimony that Kelly Harris wasn't already in a fatal downward spiral when she was released from the hospital?
Was she
In an irreversible state?
So what's the question again? That
Is it your opinion that she couldn't have been on an unalterable course because of the obesity, all of the 29 diagnoses that she had? At least a third of them are symptomatic of heart attack and stroke. She had stage 3 kidney failure.
Okay.
She was dehydrated.
So the question would be.
The question is, it's your testimony that she could not have died of a heart attack on the morning of November 5th.
My medical opinion, based on my experience, my knowledge, my 31 years of being a medical examiner, she died of diabetic ketoacidosis secondary to diabetes.
So your sworn testimony is that?
My opinion, yes.
And that same question as to a CVA, a thrown clot stroke.
Your Honor, I appreciate what counsel is trying to do here. This is cross-examination. Obviously, he's entitled to significant leeway, but I feel like we're really going over the same ground over and over at this point. The doctor's been very clear on what he determined the cause of death to be. He obviously did not determine it to be any of the other things that counsel is suggesting. I think we're just sort of rehashing the same testimony and the same information at this point. So asked and answered is my objection.
Mr. Faber?
I was wrapping up. I have one final question.
Let's go ahead and wrap it up.
Would it have been difficult? I know it took it was a half hour, you know. Would it have been difficult to order blood work or events that are consistent with with at least a third of her diagnoses?
I ordered a toxicology screen because I wanted to make sure, and we also wanted to review her medical records, that the disease process was consistent.
So it actually wouldn't have taken any more time because you need blood for the toxicology screen to check for opioids and overdose and things like that, right? It wouldn't have taken any extra work to submit to rule out, because isn't that what differential diagnoses are? You start with a theory and then you say, well, could it be this and this?
Right.
And then you rule those out. Isn't that proper medicine?
Between the three providers, you probably have 80 years of experience that were involved in the decision-making process that have seen this condition numerous times. And it was our conclusion based on the data that she died of DK from diabetes.
Oh, so you're grouping in other unnamed.
Well, we talk during the investigative process. I talked to the Davids. Okay, what'd you see? What'd you see?
It's your signature, correct?
Absolutely. At the end of the day, it's my call.
I have no further questions. Sure. Well, maybe I do. When were her cardiac enzymes normal?
October 13th is what I told you. We admitted she had the sink slip. So.
I don't have any further questions.
Any redirect?
Nothing further from this witness from the people, Your Honor.
This witness be excused.
As far as I'm concerned, Your Honor.
All right, doctor, thank you for your patience
Thank
today. You are free to leave.
You guys have a wonderful day.
Thank you.
Take care.
Okay, friends, that was all they were able to get to yesterday. Other than they had a brief discussion about bond after this and clarified one of her bond conditions because it was a little bit vague, because it was around her ability to still conduct business. And basically what the judge clarified is that this defendant during this case is still allowed to be a part of the business, but only on an administrative role. So ordering of supplies, signing paychecks, things like that, but she is not allowed to get anywhere near a patient. She is not allowed to make any medical decisions, none of it. So anything revolving directly around a patient, she can't be a part of. So that was clarified. They will be back Monday, the 27th in the afternoon, obviously when we're not on the air. So I will catch that, I'll capture it, and then we'll probably go into it Tuesday morning. So that's where we leave it for now. Hope you guys had fun today. I did, so much so we'll do it again tomorrow. Super Friday. 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. If you're not a channel member, consider fixing that. We have fun on the pre-show, but you have to be a channel member to join us there. So go have yourselves a great day. We'll see you tomorrow. Take care. God bless.